In 1891, in a county courthouse in western Pennsylvania, a probate filing listed 800 acres and the mineral rights beneath them, and listed them, quietly, as belonging to a nephew who had never worked a day on that land. The widow who held the original deed said nothing in that courtroom. She had already done everything that needed to be done. The parlour is the same in every house of this kind, not the same wallpaper. In one it is deep sage and ivory, a willow pattern repeated in careful rows. In another, burgundy silk damask that absorbs the afternoon light and gives back something quieter. But the feeling is the same. The coal fire has been burning since mid-morning, and the room carries that particular warmth that belongs only to well-heated interiors in November. Not the warmth of sunshine, which moves and lifts and disappears, but the warmth of a room that has been tended. The curtains are half drawn. The light that comes through them is the pale gold of late autumn in America, the light of a country that has just finished its harvest and is settling in for the long interior months. There is a writing desk in each of these parlours. Sometimes it's a secretary with a drop-front lid, the kind with small drawers inside for stamps and nibs, and the thin, folded letters that never quite open flat again once they have been carried across a county. Sometimes it is a simple table with a leather surface, worn to the colour of old moss, where the ink has dried in rings from years of setting the inkwell down in the same place. The pen moves across the paper with a soft, deliberate sound, the sound of someone who writes the same way they do everything else in this house, carefully, without hurry, without waste. The women who sat at desks like these were not, in the general understanding of their era, women of consequence. They did not attend legislative sessions. They did not appear in the society columns for anything except deaths, marriages, and the occasional charitable subscription. They were spinster aunts, widows, heiresses in waiting, housekeepers of long tenure and deep loyalty. They were the women who were expected, in the language of the time, to be managed, whose property was always about to be made the business of some nephew, some executor, some well-meaning brother-in-law with a better sense, he felt, of what ought to be done. What the nephews did not understand, what the brothers and executors and trustees consistently underestimated, was the desk, the records inside it. The 30 years of household ledgers and correspondence and receipts filed in order by year, tied with ribbon and labelled in a hand that had not changed since girlhood. The original deed, copied twice and stored separately. The codicil, witnessed and recorded, carried to the courthouse on a Tuesday in February when the ground was frozen and the carriage horses had to be roughshod for the ice. These women understood something that their era's legal system was slow to admit, that memory is vulnerable, but paper is not, that a record filed in the right place at the right time under the right name would outlast any man who believed he had arranged things to his advantage. The stories in this collection are fictional. They are drawn from the texture and the legal landscape of the Gilded Age, from the real dower rights and separate estates and probate proceedings of that era, from the documented inheritance battles that reached county courthouses across America between the 1870s and the 1940s. They are not the stories of any single family. The legal concepts used, dower rights, codicils, probate, quitclaim deeds, mineral rights, trusts, are drawn from the period and used for atmosphere and for accuracy. They are not legal advice. They are something quieter than that. They are the record of women who kept their own counsel, who trusted their own records, and who, in the end, outlasted the men who believed they had outmaneuvered them. This is not a collection of revenge stories. There is no confrontation, no courtroom drama, no triumphant moment where the villain is exposed. What there is, in each case, is something more durable, the quiet completion of what was always already true. The deed was always in order, the record was always correct, the codicil was always there. All that was needed in the end was patience and the willingness to let the documents speak for themselves. These women knew 3 generations of nephews, in some cases quite literally. The nephew who arrived first with questions about the will, then his son with questions about the deed, then his grandson with questions about the mineral rights. Each generation a little more confident, a little more certain that the old aunt had forgotten or grown confused, or simply could not have understood what she was signing. Each generation slightly surprised to find the parlour still occupied, the desk still in use, the record still intact. Come and sit with them now. The fire is warm, the pen is quiet. Outside, the bare November trees are just visible through the half-drawn curtains, and the street below is settling into the long, slow silence of a weekday afternoon in a prosperous town in the American interior. There is no urgency here. There never was. The work has already been done. If you enjoy listening to stories like these, stories of women who kept their records and held their ground, do consider subscribing. New collections like this one arrive each week, and the next story is always waiting when you return. A note before we begin these 5 cases. The legal landscape of Gilded Age America was changing rapidly in the final decades of the 19th century, and the changes were uneven in the way that legal changes always are. The law moving in one direction, the practice of the law moving more slowly, the expectations of the people involved moving more slowly still. The Married Women's Property Acts, passed in most states between 1839 and 1900, gave women formal legal standing with respect to their own property. But formal legal standing and practical access to that standing were different things, and the distance between them was wide and inconsistently mapped. The women we are about to meet were not unusual in the rights they held. They were unusual in the specific combination of preparation, documentation, and patient attention that allowed them to make those rights legible when the moment required it. Each of them had done in advance the thing that most people do not think to do until it is too late. They had made the truth of their situation visible in a form that could be found and read, and verified by someone who had not been present when the truth was established. They had, in other words, kept records. What follows is the story of what those records made possible. Before we begin, consider what it meant in 1878 for a woman's name to appear on a property deed. Consider what it cost: the notary's fee, the recording fee, the trip to the county seat in weather that didn't always cooperate, the deliberate act of a father who wanted his daughters' names written in a public record before he died and could no longer protect them. In Pennsylvania that year, the Married Women's Property Act had been law for 11 years, but the law and the practice of the law are different creatures, and the practice had not yet caught up everywhere. Consider all of that, and then consider what it meant when a nephew arrived, 20 years later, with a different set of documents and a quiet suggestion that the original might have been filed in error. The Whitfield house stood at the top of a long slope of meadow that the family had always called Prospect Hill, though it appeared on no map by that name. The naming was unofficial, of the kind that accumulates over generations the way that certain rooms in a house accumulate their particular smell, beeswax and old wood and the specific mineral quality of stone that has been heated by fires for 50 years, until it is no longer possible to imagine any other name. The house faced south. Josiah Whitfield had chosen the orientation for 2 reasons. The light, which in the afternoons of autumn and winter came at a long angle across the valley and fell through the south-facing windows in a way that made the parlour warm without the fire, and the view, which extended down the slope and across the creek bottom and up to the ridge on the far side, a view that changed with every season and every hour of light in a way that Josiah had never grown tired of watching. The house was built of limestone from the region, a pale grey that held the cold of morning and the warmth of afternoon with equal capacity, so that stepping close to its wall at any hour told you what the day had been doing. The mortar between the blocks was the colour of old cream. Frost formed in the mortar lines in January and needed brushing away before it worked into the stone. In summer, after a day of sun, the south wall radiated a gentle heat well into evening. The foundation was deeper than was strictly necessary. Josiah had been a cautious man, and the root cellar under the kitchen was carved from the natural limestone of the hillside, so that even in August it maintained the temperature of a May morning. Constance and Harriet had always called the root cellar the coolest room in the house, by which they meant the room with the most consistent character, the room least affected by what the rest of the world was doing. Constance Whitfield was born in this house in 1829. Harriet was born in it in 1834. They had grown up within its rooms, had learned its rhythms and its silences, had understood its particular arithmetic, the amount of coal required to keep the parlour warm through a February night, the number of cord of wood needed for the kitchen stove through a winter, the quantities of the root cellar stores that needed replenishing before November, so that December would not catch them short. Their mother, Anne, had managed this arithmetic for 30 years before her death in 1859, and she'd communicated it not by instruction, but by practice. Constance had absorbed it by watching, and Harriet had absorbed it by watching Constance, and the result was two women who knew exactly what the house required and who provided it without ceremony. Their father, Josiah, was a quieter presence in the household than the house itself. He was a capable man who respected capability in others regardless of its form, which was not universal among men of his time and place, and he had treated his daughter's management of the household with the same attention he gave to the management of the mill, observing what worked, noting what didn't, trusting the people who had demonstrated they knew what they were doing. He had never been condescending. He had also never been, in the way that some fathers of that era were, actively engaged in preparing his daughters for the particular complexities of managing property as women. That kind of preparation required seeing a threat that hadn't yet materialized, and Josiah had been a man who dealt with what was in front of him. The threat materialized, as these things do, after he was gone. The mill on the Susquehanna had been Josiah's life work, and by the late 1860s it was also his chief concern. The railroad had changed everything about the movement of goods in the region. Grains and timber and coal, all moved by rail now, at prices and in quantities that the river mills couldn't match, and the Whitfield mill was contracting year by year toward a smaller and more specialized role. Custom grinding for local farms, the sawing of timber too irregular for the big mill operators, the niche work that the large operations didn't want. Josiah had adapted without complaining. It was not an easy adaptation, but it was a dignified one, and the income, though reduced, remained reliable. He had invested what he had accumulated in his prosperous years into the house and the 40 acres around it, which he considered a more durable store of value than anything the railroad economy had on offer. Josiah's son George was born in 1837, 6 years after Constance. He was a pleasant man, pleasant in the specific way of someone who has decided that pleasantness is the most efficient social strategy, and he had left Prospect Hill at 22 for Philadelphia, where the dry goods trade suited him in the way that the mill had suited his father. It was comprehensible work, the kind where you could see what you were doing and measure whether you were doing it well. He married Frances in 1865, a woman from a New Jersey textile family whose income was larger than her personality required, and they had children with the regularity and intention that was expected of prosperous middle-class Philadelphians in that era. George was not cruel, and he was not covetous, and he was not by nature dishonest. He was, however, the father of Edmund Whitfield, which would eventually matter. Josiah Whitfield began thinking about his will in the spring of 1872, when he was 72 years old, and when his doctor had told him, with the careful bluntness of a physician who respects his patient's intelligence, that his heart was showing signs of the kind of strain that had a specific trajectory. He was not surprised. He had felt the change himself, in the way that people who have paid attention to their bodies for 70 years feel the beginning of a different relationship with them. Not pain, exactly, but a new effortfulness to things that had previously been effortless, a need to pause at the top of the slope that he hadn't felt the year before. He went to Alderman Fisk in April. Fisk's office was on the main street of the county seat, in a building between the courthouse and the post office that had housed Fisk's practice since 1835. The building had a painted wooden sign, the lettering done in 1842 by a painter who had long since moved west, that read, A. Fisk, Attorney at Law, Deeds, Wills, Estates. The paint had been touched up twice since then, but the lettering style remained the same as the original, and the sign had become a kind of landmark in the way that things become landmarks when they have been in one place long enough that people stop registering them as choices and start experiencing them as facts. Fisk was 71, white-bearded, and possessed of the particular stillness that belongs to people who have spent 40 years listening to other people's problems and have learned that most problems clarify themselves if you give them time. He and Josiah had known each other in the way of men in small counties who deal in adjacent kinds of business, not intimate, but grounded in a shared understanding of what each was and wasn't likely to do. Josiah trusted Fisk. More specifically, Josiah trusted Fisk's understanding of what the law could do for people who didn't trust the future to look after itself. The conversation they had that April afternoon lasted 2 hours. At the end of it, Josiah had a clear understanding of what a joint tenancy in fee simple meant, why it was the appropriate structure for leaving the house to his daughters, and what each of those 3 words, joint tenancy, fee simple, meant in terms of what no one could take from the women who held them. Fisk explained the Married Women's Property Act of 1867 and its relationship to the older dower right tradition. He explained why the 1867 Act, despite its relative clarity, had produced in practice a period of legal uncertainty, during which deeds needed to be drawn with particular care. He explained that the care he was proposing to take would cost something in time and in formality, but that the formality was the protection, and that protection was what Josiah was coming to him for. Josiah died in November of 1872 before the first frost had fully set in, on a Tuesday evening in the parlour chair. He died without drama, with no apparent discomfort, in the room he had sat in every evening of his adult life, with the coal fire burning and the south windows dark and the house quiet around him. Constance found him when she came to bring the evening tea. She stood in the doorway with the tray in her hands for a moment that was longer than she could measure. Then she set the tray on the table beside the door and went to sit in the opposite chair. She sat with him until Harriet came looking, and then together, as they had done everything else for 50 years, they did what needed to be done. The funeral was small. Josiah had been a private man, and the November cold discouraged attendance. George and Frances came from Philadelphia with the children, filling the house with the particular disruption of people who are genuinely grieving and also cannot quite stop noticing that the house is not arranged the way they would arrange it. Frances said nothing direct. She had perfected over the years a particular way of running her hand along a surface that communicated her opinion of its maintenance without requiring her to state it. Constance observed this without comment. After the funeral, after the neighbours and the minister and the mill workers who had come to pay their respects had gone, Constance had put on her coat and gone to Alderman Fisk's office to complete the registration of the deed. Fisk was there. He was always there. He walked her through the steps, to the county recorder's office next door, through the filing of the deed, the recording in the deed book under entry number 1872-847-W, the confirmation of the entry in the recorder's own hand. He showed her the page. He pointed to the names, Constance Whitfield and Harriet Whitfield, written in the recorder's careful clerk's script, and said, "That is yours. Both of yours." Then he went back to his office and wrote the covering letter, which arrived 3 days later, delivered by his clerk on a Thursday morning when the sky was the white-grey of an approaching snowstorm and Harriet had just put the first batch of Christmas biscuits in the oven. Constance read the letter at the kitchen table, with the smell of baking biscuits in the air and the first flakes of the promised snow beginning against the kitchen window. Then she put it in an envelope and put the envelope in the lower right drawer of the writing desk in the parlour, which was where important things went. The years between 1872 and 1878 had their own texture, which is the texture of all years in which nothing dramatic occurs. Seasons, harvests, the small repairs that houses require and receive, the correspondence with George and Frances, the management of the tenant farmer's lease, and the kitchen garden and the cellar stores. The wisteria on the south porch grew more established each spring. The kitchen cat, a grey female named Prudence, who had no opinion about property law whatsoever, died in 1875 and was replaced by an orange male named, also by Harriet, who named all the cats, Cornelius, who had an opinion about everything and expressed it at length. Constance and Harriet were not women who discussed their emotional lives in great depth. This was not repression. They were entirely capable of warmth, and they demonstrated it regularly to the tenant farmer and the minister's wife and the children of the neighbouring farm who came to pick apples in September. It was simply that their relationship with each other had achieved, over 50 years in the same house, the kind of efficiency that very close relationships sometimes develop. They knew each other's positions on most questions without needing to state them, and they communicated what mattered through action rather than through declaration. When Constance went to Fisk's office in March of 1878, after reading the newspaper article about the property dispute in the neighbouring county, she told Harriet where she was going. Harriet said, "Good." And that was the entirety of their discussion of the matter until Edmund arrived 2 months later. Edmund Whitfield had spent 2 years at a law firm in Baltimore, and he had emerged from those years with a thorough understanding of property law and a particular interest in what he would have called, if pressed, the creative interpretation of transitional legal documents. He was not a dishonest man, and his approach to the question of the Whitfield deed was not straightforwardly dishonest. It was something more complex than dishonesty. It was the application of legal learning to a family situation in a way that he had somehow managed to frame, even to himself, as both legitimate and kind. He was doing his father a service. He was, he told himself, also doing his aunt a service, by clarifying a legal situation that was, he believed, genuinely uncertain. He arrived in late April, the wisteria just showing its first colour. He had the leather portfolio and the expression of a man who was prepared for a difficult conversation. Constance met him at the door and offered him tea and sponge cake, and Harriet sat in the window chair with her needlework, and Edmund laid out his case with the care of someone who has rehearsed it. He cited the relevant Pennsylvania case law. He explained the ambiguities in the 1867 Act. He suggested, with every appearance of reluctance, that the phrase joint tenants, in the context of the period's legal uncertainty, might be construed in a way that would not serve his aunt's interests. He said the word unfortunately at the appropriate moments. Constance listened to all of this. She asked whether he had reviewed the original filing at the county courthouse rather than his father's copy. She asked when he had last spoken to Alderman Fisk. Edmund had done neither of these things, and he said so, and Constance said she thought that might account for some of the confusion. She thanked him for coming and walked him to his carriage. Edmund's subsequent visits, June, August, September, followed a pattern that Constance observed with the kind of dispassionate attention she brought to all recurring phenomena. In June he brought a letter from George, expressing concern in the vague way of a man who has been prompted to express something without being entirely sure what he is expressing. In August he brought the opinion from the Baltimore attorney, 2 pages of subordinate clauses that Constance annotated in pencil and filed in the folder labelled EW Ongoing. In September he brought the quitclaim deed, prepared on good paper, its terms generous on the surface, and completely contrary to the original deed in every sense that mattered. The quitclaim presented itself as an act of family solidarity. It guaranteed Constance and Harriet the right to remain in the house for the duration of their lives. It provided for their reasonable maintenance. It transferred all legal ownership, all the rights that would survive them, to the Whitfield Family Trust, administered by George, with Edmund as successor trustee. It would, if signed, replace the 1872 deed in the county records with a document that reduced the sisters from owners to occupants, which was a reduction of considerable significance. Edmund presented this document with the air of a man who has done something difficult but necessary. He said it simplified everything considerably. He said it would protect the sisters, particularly in the event of any future legal uncertainty about the original deed. He appeared to believe these things, which made his presentation more convincing and also, somehow, more troubling than it would have been if he had simply been attempting an obvious deception. Constance said she would like to show him something. She went to the desk. She removed the 2 envelopes from the lower right drawer, the certified copy of the deed, and Alderman Fisk's covering letter, with the March 1878 addendum folded inside the letter's envelope. She placed them on the table without comment and waited while Edmund read. The certified copy was exactly what it had always been. Fisk's letter was exactly what it had always been. The addendum, which Edmund had not known to expect, addressed directly the line of cases he had cited, explaining why they did not apply to the Whitfield deed. Edmund read the addendum twice. He read the certified copy again. He set everything down with the controlled quietness of a man who is reassessing a situation. "I see," he said. "Alderman Fisk wrote that addendum in March," Constance said. "He's still in practice. He's prepared to provide an affidavit. The original deed is in the county deed book, under entry number 187-2-847-W. I verified this personally in March. The county recorder has been in his position since 1864 and remembers the filing." She said all of this in the same tone she used when explaining household accounts to the tenant farmer. Factual, neither warm nor cold, simply accurate. Edmund left without the quitclaim. He was civil at the door and down the steps and into his carriage. He was the particular kind of civil that belongs to people who have been shown to have been wrong, but who are not yet ready to acknowledge it in any explicit sense. He returned in the spring of 1882 after Alderman Fisk had died. His argument by then had shifted. He suggested procedural irregularities in the original recording, a position that had no more merit than his previous arguments, but that had acquired, with Fisk's death, the superficial plausibility of a claim that its primary refutation could no longer be called upon directly. Mrs. Abigail Fisk, who had taken over her late husband's practice, dealt with this argument in a letter of 4 pages that Constance and Harriet had not asked her to write, and that she had written because she found the suggestion personally offensive. Mrs. Fisk had read every document in her husband's client files. She knew what he had done and why and how well he had done it. She addressed Edmund's attorney's claims in sequence with citations, with copies of the county court entries, with a precision that made the procedural irregularities argument look like what it was, an argument produced by someone who had not actually reviewed the documents. The letter closed with 2 sentences. If Mr. Edmund Whitfield has additional claims he wishes to raise regarding this property, this office stands ready to address them with the same care it has given the present inquiry. I would note, however, that the costs of continued litigation would, in my professional opinion, substantially exceed any benefit that could plausibly accrue to Mr. Whitfield's client from any achievable outcome. Edmund's attorney wrote back once, a brief letter that acknowledged the receipt of Mrs. Fisk's communication and indicated that his client was giving the matter further consideration. No further communication followed. Constance and Harriet Whitfield lived in the house on Prospect Hill for 26 more years after Edmund's last visit. They were not years of drama. They were years of management, the lease renewals, the kitchen garden, the repairs that stone houses require at measured intervals, the correspondence with the Presbyterian Church whose educational fund they had decided, sometime in the 1890s, to support with what they would eventually leave. The wisteria continued to grow. The kitchen cats continued to arrive, be named, and depart in the natural order of things. The lower right drawer of the writing desk continued to hold its documents, which continued to say what they had always said. Constance died in October of 1901. She was in her room, in the house she had always been in, and Harriet was with her. The October afternoon was mild for the season, and through the window the valley was showing the first colours of autumn, the maples going from green to amber to the deep red that arrives before the leaves fall, the fields below still holding their harvest pale. Harriet sat with her sister through the afternoon and into the evening, and when it was over she went to the kitchen and made tea, which was what she had always done when she needed to do something, and she sat at the kitchen table with the cup in her hands and thought about 67 years of sharing a house with someone and what it meant to stop. She managed alone for 2.5 years, with the support of the tenant farmer and the neighbours and the church community, and she died in the spring of 1904. The property passed to the Presbyterian Church. Edmund Whitfield attended the auction of the house's contents in 1906 and purchased the writing desk, paying $42 for it, which was less than it was worth but more than anyone else bid. He used it for 30 years in his study in Philadelphia. In 1936, when Edmund died and his own estate was being settled, the desk came up at auction again. His son had no interest in old furniture. The desk sold to a dealer in Germantown for $30. Its lower right drawer was empty. Everything that had been in it, the certified copy, the covering letter, the addendum, the folder labelled EW, ongoing, was in the church's estate files, where it had been since Constance had placed it there in the autumn before her death, with a brief note attached in her handwriting explaining what each document was and why it had been kept. The note was in her usual hand, the hand that had not changed since girlhood, the same hand that had written the household accounts and the tenant farmer's receipts and the letters to George and Francis for 60 years. It said, "These documents relate to the Whitfield deed registered at the Susquehanna County Courthouse in December 1872 under entry number 1872-847-W. They have been kept in order since that date. Anyone with questions may consult the original deed in the county records. The records are complete and accurate." And then, below her name and the date, "The deed has always been in order. It remains so." The house on Prospect Hill became a school for county children in 1910, funded by the church's educational foundation. The slope of meadow below it was used for the children's recreation. In spring, when the wisteria bloomed, the children played on the south porch under the purple clusters that hung so thickly that they shadowed the porch boards, making a kind of cool, green and purple room under the flowering vine that smelled of something between honey and rain. The desk Alderman Fisk had designed the deed for had been in the school's principal's office since 1940, when someone had found it in a Philadelphia auction catalogue and recognised the family connection. Its lower right drawer held the school's petty cash, which was not what it had been designed for, but which it held perfectly well. The drawer was solid, the wood still good, the mechanism smooth after 70 years. Old houses and old furniture are like that. They outlast the purposes they were built for, and then they serve whatever purpose comes next, and they do it without comment, because wood and stone do not have opinions about what happens to them. They simply continue, holding what they are given in the condition in which they were made. There is a quality particular to houses that have been occupied by the same family for 2 or more generations, a quality that is not quite atmosphere and not quite memory, but something that partakes of both. It accumulates in the way that warmth accumulates in stone, held below the surface and released slowly, imperceptibly, to anyone attentive enough to sit still and notice it. The Whitfield house on Prospect Hill had this quality in abundance. It was in the way that the south-facing rooms received the morning light in summer, the angle of it through the windows on the parlour floor making a particular pattern on the boards that Constance and Harriet had known since childhood. It was in the way that the root cellar smelled in July, cool and mineral and specific in the way of places that have been sealed from the seasons for a very long time. It was in the way the wisteria moved in a light wind, the old wood of it making a sound that was almost language, almost meaning, almost the voice of something that had been in that location long enough to have formed an opinion. Constance Whitfield's method of maintaining order was architectural rather than systematic. She did not impose systems so much as she arranged things logically, and then relied on the logic to maintain itself. The writing desk was an example of this. Its drawers had been assigned to specific categories of content almost from the moment the desk had arrived in the parlour in the 1840s, when their mother had received it as a wedding gift, and those assignments had never changed. Correspondence went in the upper left drawer. Bills went in the upper right. Household accounts went in the long middle drawer. The lower left held stationery and envelopes and the spare pens and the inks. The lower right held what Constance thought of as the permanent documents. The things that were important enough to keep, but not important enough to require the formal attention of a professional's filing system. The deed to the house had lived in the lower right drawer since December of 1872. It had never been moved. Harriet's relationship to the house was different from Constance's in the specific way that the relationships of younger sisters often differ from those of elder. She'd inherited the house's rhythms rather than establishing them, which meant she felt them more than she thought about them. She knew without thinking that the second step of the back staircase creaked, unless you stepped to the far left side, and that the kitchen window in the afternoon produced a draught if the upper sash was not properly latched, and that the root cellar needed checking after any period of heavy rain to ensure that the drainage channel was clear. She knew these things the way she knew the recipes for the preserves she put up every autumn, not as procedures that she followed but as knowledge that she inhabited. The house was, for Harriet, less a place she lived in than a condition she occupied. The tenant farmer who worked the lower field was named Bernard Kopp, a man of German ancestry who had come to the county in the late 1850s and had worked the Whitfield lower field since 1863. He was reliable in the way of people who have found a situation that suits them and have no particular interest in changing it. He paid his rent on the first of each month in coin, which he brought to the house himself, handing it to whoever answered the door with a nod that was both a greeting and a receipt. He did not ask questions about the house's management, and he did not offer opinions about it. He had been farming the lower field when Josiah was alive, and he continued farming it after Josiah's death, and the question of who owned the land above the field was not, in his estimation, his concern. He had, however, been aware of Edmund Whitfield's visits, and he had noticed, without being asked, that they had stopped. One of the questions that Edmund Whitfield's legal research had not adequately addressed was the question of what the law intended versus what it produced in practice. The Pennsylvania Married Women's Property Act of 1867 had been passed with the intention of giving married women legal standing with respect to their own property, but the act had been drafted by men who were, in many cases, not entirely certain they wanted the outcome they were legislating. The result was a law that was clearer in principle than in application, and that had produced in the 11 years between its passage and Edmund's first visit to Prospect Hill a number of court cases in which the application was disputed and the outcomes were inconsistent. Edmund had read those cases carefully. What he had not read was Alderman Fisk, who had also read those cases carefully, had formed clear opinions about them, and had drafted the Whitfield deed in explicit response to the ambiguities they revealed. Alderman Fisk had been practicing law in that county for 40 years, when he drew up Josiah Whitfield's will in 1872. In 40 years of practice, he had seen many things that the law permitted, in theory, fail in practice, and many things that the law prohibited in theory succeed in practice. And he had developed from this experience a conviction that the most useful thing a lawyer could do for a client was not to explain what the law said, but to draft documents that removed as far as possible any gap between what the law said and what the client actually needed. The Whitfield deed was an example of this conviction in action. He had used joint tenancy and fee simple, not because it was the simplest structure, but because it was the most resistant structure. It removed the ambiguities that the newer Act had introduced. It gave the sisters the strongest possible form of ownership, and it did so in language that was unambiguous in the County Court's deed book, which was where ambiguity mattered most. His covering letter to Constance had been his other instrument of protection. Fisk understood something that younger attorneys sometimes missed, that a legal document is only as good as the knowledge of the people who hold it. A deed that says exactly what it needs to say is useless if the person who holds it doesn't understand what it says. He had written the covering letter not for lawyers, any competent lawyer who read the deed would understand it, but for Constance, so that she would understand what she held and why it was strong, so that when someone told her the deed was ambiguous, she would know, in her own understanding, that it was not. He had written it in short, so that she could recognize wrong when someone presented it to her as right. The wisteria on the south porch had been planted by their mother in the spring of 1847, the year of Harriet's birth. Anne Whitfield had bought the cutting from a neighbour who had brought seed from the south, and she had planted it on the south side of the porch with the intention of giving the porch shade in summer without blocking the winter light. She had trained the first few years' growth along the porch railing with strips of cloth tied to nails, guiding it the way she wanted it to go. After about 5 years, it had decided where it wanted to go and had gone there, and subsequent management consisted mainly of cutting back the parts of it that were threatening to become structural liabilities while allowing the rest to do as it pleased. By 1872, the year of Josiah's death, the wisteria had become partially structural itself, its old cables of vine providing genuine support to sections of the porch railing that had grown dependent on it. By 1882, when Edmund made his last visit, the wisteria and the porch were effectively one thing. Mrs. Abigail Fisk had not been universally welcomed when she assumed her late husband's practice. This was not unusual. Women who inherited professional practices from their fathers or husbands in that era faced a specific kind of resistance, not the overt resistance of outright refusal, but the more diffuse resistance of clients who were suddenly very busy when they needed to make appointments, or who discovered that their needs had changed, or who expressed polite concern about whether Mrs. Fisk would be able to manage the demands of the practice given her circumstances. Mrs. Fisk managed the demands of the practice by working longer hours than her husband had, and by knowing his files better than he had, which was easy because she had been helping him with them for 30 years in the unacknowledged way that competent wives help competent husbands with their work without anyone accounting for it in the formal record. She had the files, she had the knowledge. She had, above all, his letter files, which contained 40 years of correspondence that she could read in any direction and use for any purpose. When Constance and Harriet retained Mrs. Fisk after Alderman Fisk's death, they did so because Mrs. Fisk had written to them first. She had gone through the active client files and identified the Whitfield matter as one that might require attention, and she had written to Constance a brief letter noting that she had taken over the practice and that the Whitfield deed and related correspondence were in her files, and that she was available if they needed her. Constance had replied that she was glad to know this, that she hoped Mrs. Fisk would not find the work too demanding, and that she expected they might need her assistance in the near future. They had corresponded briefly and practically in the manner of two women who understand each other's situation without needing to describe it explicitly. The folder labelled E.W. Ongoing had accumulated, by the time Edmund made his last visit in 1882, a set of documents that Constance and Harriet found instructive in ways that went beyond the specific case. There were Edmund's 4 letters, there was the Baltimore attorney's opinion, annotated in Constance's pencil. There was a copy of the newspaper article about the property dispute in the neighbouring county that had prompted Constance's March visit to Alderman Fisk. There was Constance's own note written in 1880, summarising her understanding of the relevant Pennsylvania case law and why it did not affect the Whitfield deed, based on her conversations with Fisk and her own reading of 2 of the cases, and there was, tucked at the back, a brief note in Harriet's hand that said simply, "C has this under control. H.W." The note was dated September of 1878, the week after Edmund's Quitclaim visit. It was not addressed to anyone. It was simply Harriet's private opinion, committed to paper in the same drawer where the more official documents lived. In the years after Edmund's visit stopped, the house continued on. The tenant farmer paid his rent, the wisteria flowered, the kitchen garden produced, and Harriet preserved, and Constance recorded everything in the household accounts, with the same neat hand she'd been using since she was 15 years old. They had letters from George about the dry goods business, and later from Edmund himself about his law practice, which had established itself modestly in Philadelphia, and which he appeared to manage with the competence he had always shown in matters that didn't involve the Whitfield property. They did not discuss Edmund's visits in their correspondence with George. There was nothing to discuss. The matter had been handled. The documents were in the drawer. What the story of the Whitfield sisters illustrates when you look at it from a distance is not unusual as a pattern. It is in fact a pattern that appears throughout the Gilded Age inheritance records, wherever women had had the foresight or the fortune to hold clearly documented property. The threat was almost always the same. A male relative, genuinely or with calculation believing himself entitled, appearing with documents or arguments designed to complicate or replace the existing record. The response that worked was almost always the same. The original document, clearly drawn, clearly filed, accompanied by the kind of professional correspondence that confirmed its meaning and its intent. The threat required confidence and legal assistance. The response required only what was already there. This asymmetry, the attacker needing to construct something new, the defender needing only to produce what already existed, favoured the women who had kept their records. It was the only legal advantage that consistently worked in their favour. Constance died in October of 1901. The house was quiet that autumn in the way that houses become quiet around deaths. Not more silent exactly, but differently resonant, as though the air has absorbed something and is still deciding what to do with it. Harriet managed the 2.5 years that followed with the steadiness she had always had, which was not the steadiness of someone who does not feel things, but the steadiness of someone who feels them thoroughly, and then continues anyway. She walked the south porch in the evenings, when the wistaria's bare November cables made their particular silhouette against the valley view below. She put up the preserves each autumn. She wrote to George and to the church and to Mrs. Fisk, who remained in practice until 1898, and then retired to a house in the county seat, from which she continued to correspond with clients she cared about, which included the Whitfield sisters. The house on Prospect Hill became a school for county children in 1910, funded by the Presbyterian Church's Educational Foundation. The schoolroom was established in what had been the parlour, which meant that the writing desk was moved to the principal's office on the second floor. The lower right drawer, empty now, was used for petty cash and for the key to the coal cellar. The wisteria, which the schoolchildren were told not to climb, continued to grow in the direction it had always grown, toward the south, toward the light, along the porch railing where Constance and Harriet had stood on so many evenings watching the valley below settle into its particular evening colours. In 1936, the school held a brief ceremony acknowledging the 30 years since the Whitfield bequest had made the educational fund possible. A local historian had researched the family's history and prepared a short account of it, which he read to the assembled parents and children on a Saturday afternoon in May, when the wisteria was at its fullest bloom and the south porch smelled of it. The account mentioned the Whitfield sisters' management of the property. It mentioned their father's will. It mentioned Alderman Fisk. It did not mention Edmund Whitfield, who had died that same year in Philadelphia, and who was in any case not part of the story the historian was telling. The story the historian was telling was about women who had held their ground, who had trusted their records, who had allowed the documents to speak for themselves when the moment came. The school principal, listening to this account, thought about the writing desk in her office, in whose lower right drawer she kept the petty cash. She had heard from the church's archives some version of the desk's history. She thought about the drawer, and what it had held and what it now held, and the difference between the two. Then the ceremony ended, and the children went outside to play on the south slope under the wisteria, and the afternoon continued. Pennsylvania property law in 1878 was in a state of productive confusion. The Married Women's Property Act of 1848 had extended to married women the right to hold separate property, and its subsequent amendments through 1867 had expanded those rights in several directions. But the statutory language, as statutory language tends to be, was imprecise at the edges, and the decades following the Act's passage had produced a body of case law that was inconsistent in the way of case law generated by courts that have not yet decided what principle they are actually applying. A deed like the one Alderman Fisk had drawn for the Whitfield sisters, joint tenancy in fee, simple, clear of any life estate limitation, was unambiguous within that body of law. The problem was not the law. The problem was the expectation that women who held such deeds would not know they held them. Edmund Whitfield had, in fairness, made a practical calculation. His calculation was that Constance and Harriet were women of the period, educated in the domestic arts, capable in the household, unused to the specific language of property law, and that they could be guided to understand their situation as he described it rather than as it was. This was not an unusual calculation for men of his generation to make. It was not correct in the Whitfield case, but it was not an absurd expectation based on prior experience. He had simply encountered in Constance a woman who had read the document, understood it, discussed it with its drafter, and kept the drafter's explanatory letter in the same drawer. He had also encountered, though he did not know this, a woman who had read about a similar dispute in a neighbouring county, and had taken the initiative to drive to Alderman Fisk's office on a March morning to discuss it. His calculation had been wrong about the specific case. It was not wrong about the general pattern. The pattern was what made the specific case necessary. The wisteria that summer, the summer of Edmund's first visit, was at the height of its annual abundance. It bloomed in late May, and the blooms lasted through most of June, and during those weeks the south porch smelled of wisteria almost continuously. A heavy, sweet smell that had the quality of something that has been building toward this moment all winter and spring. Constance had always found it slightly excessive, in the way of things that are fully themselves. Harriet loved it completely. They had never agreed about this, and the disagreement was itself a kind of comfort. The same conversation, in various forms, each June, while the wisteria did what it did regardless of their differing opinions about it. After Edmund's last visit, the house continued its rhythms. The kitchen garden in summer, the preserves in autumn, the wood laid up against the east wall of the barn for the winter, the accounts, the letters, the visits from neighbours and from George's family in the holidays and from the minister on his rounds. Constance and Harriet did not discuss Edmund's visits very often. There was not much to discuss. The visits had happened, the documents had been produced, the visits had stopped. The story had a resolution, and the resolution did not require narration. It simply was. There is something that long-term record-keeping produces that is difficult to describe to someone who's not done it. A sense of the shape of time. When you have been recording the same things in the same format for 20 or 30 years, you acquire a feeling for what the records mean, not just as individual entries but as a continuous form. You can see the patterns that any single entry would not reveal. The way the kitchen garden's yield varies with the summer's rainfall, the way the visiting patterns of certain people shift over years, the way your own handwriting changes almost imperceptibly between decades. This sense of shape is what the Whitfield household ledger gave Constance, and it was, in its own way, a kind of knowledge. Not the specific knowledge that the deed conferred, the knowledge that the house was theirs and the specific terms under which it was theirs, but a broader knowledge of what it meant to be the keepers of a particular place and the recorders of its life. There is a particular kind of patience that does not come from indifference. Constance Whitfield was not indifferent to the threat that Edmund represented. She understood, from the moment she read his first letter in the summer of 1878, exactly what he was attempting and why he believed he might succeed, and she had a clear view of the consequences if he did succeed. Not merely the loss of the house, but the larger loss of the security that the house represented. A place that was hers, that did not depend on anyone else's goodwill, that would continue to be hers as long as the deed said it was hers. The loss of that, at 56, would have been a different kind of life. She had kept this knowledge clearly in her mind through all three of Edmund's attempts, using it not as a source of anxiety but as a source of precision. She knew exactly what she was protecting. That knowledge was what the patience came from. Harriet was 53 when Edmund made his first visit, and she had lived in the house on Prospect Hill for the entirety of her life. Her relationship to the house was therefore different in character from the relationship a person has to a place they chose or acquired. It was the relationship of origin, the place that had formed the earliest memories, and that had been the context for all the subsequent ones. To lose it would not merely have been a practical displacement, it would have been something more fundamental, the removal of the ground beneath the life she had built. She did not talk about this with Constance, because it was not the kind of thing they talked about. It was simply present, understood between them, in the way that the most fundamental things between people who have lived together for decades are present and understood. The Whitfield case was one of several hundred property disputes involving unmarried women in Pennsylvania in the 2 decades after 1867. Of those disputes, a significant proportion were resolved in favour of the nephews or male relatives, often because the women involved did not have access to the specific knowledge that would have allowed them to contest the claims effectively. Knowledge of what their documents actually said, knowledge of where to go for help, knowledge that the legal system was, in principle, on their side even if its practice was complicated. Constance and Harriet had all 3 forms of knowledge, which was the result of a specific set of circumstances, a careful attorney who had treated them as capable of understanding their own affairs, a man of unusual professional integrity who had explained the document and then explained the explanation. These circumstances were not universal. They were, in fact, considerably less common than the circumstances that produced the other outcomes. This is what makes the Whitfield case worth remembering. Not that it was usual, but that it shows what was possible when the conditions were right. Let the house settle around you as you listen to this. The things you are responsible for are not what define you, but the care you give them is. The choices about what to hold and what to release, what to protect and what to let go. These are yours. The documents in their drawers and the accounts in their ledgers are not burdens. They are the record of what you have attended to, what you have understood, what you have cared for. They speak for themselves when the moment comes. They have always spoken for themselves. This is what Constance and Harriet knew, what Margaret and Agnes and Eleanor and Miriam and Ruth each knew in their own way. The record is the testimony. The careful attention is the argument. The sustained care is the proof. And for tonight, whatever you are managing, whatever you are protecting, whatever you are holding with quiet patience, it is enough to have kept good records. It is enough to have paid attention. Let the knowledge settle into sleep. Here is the thing about mineral rights in western Pennsylvania in 1891. They were not always visible. A field could look like a field, could smell like one, could produce its annual harvest of rye or hay or winter wheat as reliably as it ever had, while beneath it something else was accumulating, something the surface gave no sign of. The men who dealt in mineral rights understood this. They understood, with a patience that was also a form of calculation, that what lay below a piece of ground could be worth 10 times what lay above it. And they understood also that a widow who had never been asked to think about such things might not know to check, particularly if the man who had known to check was no longer alive to tell her. The Holloway farm sat in a shallow valley in Caldwell County, 3 miles east of the county road and half a mile from the creek that drained into the Allegheny tributary. The soil in the valley was good enough for rye and for winter wheat, and for the hay that the lower field across the creek produced reliably, but it was not the dark bottomland that made men genuinely wealthy in that part of the state. What the farm had instead of exceptional soil was water and position. The creek along its south boundary ran reliably through drought years when other streams went dry, and the position of the valley, sheltered from the northeast wind by a long ridge, meant that the fields greened early in spring and stayed green late into autumn. Henry Holloway had farmed it for 30 years before the question of what lay beneath it became relevant, and in those 30 years the surface had been everything. Margaret had married Henry in 1858. She was 22 and he was 28, and the decision to marry had been arrived at in the way that most decisions of that kind were arrived at in Caldwell County in the late 1850s, through proximity, through mutual knowledge, through the gradual recognition that 2 people who already understood each other well might as well make that understanding official. Henry was not a romantic figure, and he had not proposed romantically. He had asked her one Sunday afternoon in October, walking back from church with the valley showing its autumn colour in every direction, whether she thought it would suit them both to be married in the spring. She had considered it for a moment, watching a crow cross the ridge, and said yes, she thought it would suit them very well. They had not embraced. They had walked home in a comfortable silence that was, in retrospect, a very accurate preview of the 31 years that followed. Henry Holloway was a methodical man. He kept his farm records in a ledger that he balanced every Sunday evening at the kitchen table, recording the week's income and expenditure in a hand that was neat without being elegant, the hand of someone who writes to be read rather than admired. He kept his correspondence in a box on the shelf above the desk, organised by year, each letter in the envelope in which it had arrived, each envelope labelled with the sender's name and the date. He read everything he received twice before he replied. He asked questions before he signed things. He treated the business of his farm with the same careful attention that other men gave to commerce or law or medicine, and the farm had, over 30 years, returned this care with the steady reliability of things that are properly managed. In the autumn of 1882, a man named Carver from Pittsburgh began appearing in Caldwell County. He was the agent of a company interested in mineral rights throughout the region, and he had a particular manner, not aggressive, not anxious, simply present. He appeared at farm after farm with a polite inquiry, a reasonable-seeming price, and the patience of someone who expects to buy most of what he is offering to buy for, and is therefore unbothered by the individual conversations that go otherwise. He had been through the county for 3 weeks before he came to the Holloway farm. Henry invited him in, offered him coffee, and listened to his proposal without committing to anything. Carver wanted the mineral rights to the Holloway farm and adjacent parcels for 12 cents an acre. He explained that the company was purchasing speculatively, that they believed there was potential for oil or gas beneath the area but weren't certain, and that the price reflected the uncertainty. Henry listened, asked several questions about the company's activities in the region, and about the geology of similar areas elsewhere in western Pennsylvania, and thanked Carver for his time. He said he would consider the offer. He showed him to the door and then stood at the kitchen window watching Carver's wagon go down the road, and thought about what 12 cents an acre told him about what the rights were actually worth. Over the following 6 months, Henry investigated. He wrote to the Geological Survey Office in Harrisburg. He corresponded with a solicitor in Pittsburgh who had experience with mineral rights transactions. He read the county newspaper and the Pittsburgh papers attentively. He talked to 2 neighbouring farmers who had sold their rights the previous year and asked them what they had been told at the time and what they had found out subsequently. What he found was consistent. The speculative purchases were not entirely speculative. The companies had surveys suggesting strong probability of oil beneath certain areas, and Caldwell County was in one of those areas. The price Carver had offered was low, considerably low. He wrote to Carver in the spring of 1883 proposing 40 cents an acre. Carver countered at 18. They went back and forth through the summer, and in September of 1883 Henry signed a purchase agreement for the mineral rights to 480 acres at 28 cents an acre. The Pittsburgh company paid the purchase price, and Henry paid the recording fees himself, which was not standard practice, but which meant that he received from the county recorder an official confirmation of the transaction that went into the leather portfolio on the second shelf of his study bookcase, behind the purchase agreement and the 2 related documents the company had provided. The purchase agreement had a clause in the second paragraph of page 4. The clause was standard language, the Pittsburgh solicitor had told him. It referred to the company's internal holding company structure, not to any limitation on the buyer's personal ownership of the rights. Henry had confirmed this in writing. He had written to the solicitor asking for written confirmation, and the solicitor had replied in January of 1884 with a 2-paragraph letter stating clearly that the mineral rights purchased by Henry Holloway were his personally, in fee simple, subject to no conditions and no reversions that would affect Margaret or their children after his death. He had then written a second letter asking the solicitor to retain a copy of the correspondence in his office files. The solicitor had confirmed receipt and retention in March of 1884. Both letters were in the leather portfolio, in their envelopes, labelled in Henry's corner-of-the-page style. Margaret had been present when Henry explained the purchase agreement at the kitchen table in September of 1883. She had been hemming a curtain at the time, and the needle was in her hand, and some part of her attention was on the curtain, and some part was on Henry's voice. But she had heard him pause at page 4, and she had heard him explain the clause and why it meant what the Pittsburgh solicitor said it meant and not what it appeared to say. She had the specific, reliable memory of a person who listens carefully to things she expects she may need to remember. This was a quality she had developed early in childhood and had never stopped exercising. Henry Holloway died on a warm evening in August of 1889 after the last of the first hay cutting. He sat down on the porch steps and did not get up again. He was 60 years old. The doctor said it was his heart. Margaret sat with him on the porch until the doctor came, and then she did what needed to be done in the patient and practical way that she had always done what needed to be done, and the house continued to function around the fact of his absence as houses do, because houses require maintenance regardless of what happens in them. Robert Shin arrived the week after the funeral. He was Henry's nephew, the son of Henry's sister Eleanor, and he was an attorney who had set up practice in the county seat in the mid-1880s. Henry had appointed him executor 2 years before his death, at Robert's own suggestion, and with Henry's considered acceptance. Robert was competent, he was family, and he understood legal matters. These had seemed like sufficient qualifications at the time. Margaret had never entirely trusted Robert Shin. This was not a position she had reasoned her way to, but one that had accumulated, the way certain kinds of knowing accumulate, from small observations over several years, from the particular way he arranged conversations so that they ended where he had already decided they should end, from the speed with which he had made himself useful to Henry in the years of Henry's decline. She had not said this to Henry because it was the kind of thing that is difficult to say without sounding unreasonable, and because she wasn't certain whether her unease was perception or simply the discomfort of someone who prefers her own counsel to someone else's. She had watched it, noted it, and said nothing, but she had not forgotten it. The estate inventory arrived in January of 1890. It was 12 pages and covered every asset with professional thoroughness. The farm equipment was listed, each item with its assessed value. The livestock was listed individually. The household contents were listed by room. The bank account was listed with its current balance. The fields were described by acreage and assessed value. The creek bottom parcel was listed. The water rights to the creek were listed separately at a value Margaret considered conservative but did not dispute. The mineral rights to 480 acres, which a Pittsburgh company had valued the previous spring at $40 an acre, were not listed. Margaret read the inventory twice at the kitchen table on a January morning. She went through it methodically, the way Henry had taught her to read documents, starting at the beginning, going slowly, checking each item against her knowledge. She reached the end without finding the mineral rights. She went back to the beginning and read it again. They were still not there. She set the inventory on the table and looked out the kitchen window at the frozen January fields and thought about the leather portfolio on the second shelf of Henry's study. At the meeting in Robert's office the following week, attended by Clara from Ohio and James from his farm, Robert explained the omission calmly and thoroughly. The mineral rights had reverted to the Holloway family company upon Henry's death, he said, under the terms of the original purchase agreement. He produced a copy of the agreement, turned to page 4 and read the clause in the second paragraph. He was measured in his delivery. He appeared entirely confident. He had the demeanour of a man who has explained something difficult to a widow and has expected her to be confused and is prepared to be patient about that confusion. Margaret listened. She looked at the page 4 clause. She thought about Henry's voice at the kitchen table in September of 1883, pausing over that clause and then explaining it. She thought, the solicitor's letters are in the portfolio. They are on the second shelf. They are there right now. She said she would need to review the matter further. Robert said he understood completely and that she should take all the time she needed. That evening, after Clara and James had gone, she went to the study. The leather portfolio was where it had always been. She opened it. Behind the purchase agreement, behind the company's related documents, were the 2 solicitors' letters. She read them at the study desk, by the light of the desk lamp, with the January cold pressing against the window and the house quiet around her. The first letter confirmed that the clause on page 4 referred exclusively to the company's internal structure and had no effect on Henry Holloway's personal ownership of the rights. The second letter confirmed that the solicitor had retained copies of the entire correspondence in his office files. Henry had known, 6 years before his death, that someone might one day dispute those mineral rights. He had taken the steps that would prevent the dispute from succeeding. He had asked the solicitor to keep copies because he understood that his own files might not be enough, that a second independent set of records in a professional's office added a layer of protection that his personal files alone could not provide. He had thought about what she would need, in the situation she was now in, and he had provided it. This was, Margaret thought, sitting at his desk with his letters in her hands, the most practical and the most loving thing he had ever done for her. She engaged Mrs. Addie Morrow, an attorney in the next county whose reputation Margaret had researched through careful inquiry over several weeks. Mrs. Morrow was in her late 40s, had taken over her father's practice upon his death, and was described by those who had worked with her as thorough, unhurried, and very difficult to surprise. Margaret brought the leather portfolio to their first meeting. Mrs. Morrow read the purchase agreement and the 2 solicitors' letters and the solicitor's copy retention confirmation with the focused attention of someone who is reading for significance. She said the situation was clear. She said she would write to the Pittsburgh solicitor for certified copies. The Pittsburgh solicitor, now retired but still maintaining his client files with the professional diligence that had made him worth writing to in the first place, provided certified copies within 2 weeks, 5 pages, signed and notarized, confirming in triplicate the substance of what Henry's portfolio already contained. Mrs. Morrow wrote to Robert Shinn's attorney. Robert Shinn's attorney wrote back requesting a meeting. The meeting was at Mrs. Morrow's office in May of 1890. It lasted less than an hour. Mrs. Morrow presented the documents. Robert's attorney read them. Robert's attorney conferred with Robert briefly and quietly, in the low voice of someone communicating a position that is not comfortable to communicate. Then he turned back to Mrs. Morrow and said that his client wished to revise the estate inventory. Mrs. Morrow said she had expected so. The revised inventory was filed in June. The mineral rights were listed at $26,000, reflecting the offer that a new Pittsburgh company had made in the spring, a number considerably higher than the earlier valuation, because certainty about what lay beneath Caldwell County had been increasing steadily for 2 years, and the competing buyers had driven the price accordingly. The rights were listed as personal property of Henry Holloway, to be held in trust for Margaret during her lifetime and thereafter distributed to Clara and James in equal shares. Robert administered the remaining provisions of the estate correctly and completely, if without the warmth that their family connection might have suggested was appropriate. Margaret treated him with the same correctness. She had not required him to acknowledge what had occurred. She had required only that the record be accurate, and the record was now accurate. That was sufficient. Clara came back that summer and stayed for a month, which was longer than she usually stayed, because she'd sensed in the spring that her mother had been through something, and wanted to be present without necessarily needing to discuss what it had been. They talked about the farm, about James's expansion of his own fields, about what Clara's children were doing in Ohio. They sat on the porch in the August evenings when the air smelled of the dried hay in the lower field, and the creek made its particular sound in the warm months, which was less a sound than an awareness, a gentle persistence that had been part of Margaret's life for 51 years. Margaret waited 3 years before selling the mineral rights. She waited because Henry would have waited, and because waiting cost nothing and might gain something, and because she had learned over 31 years of living alongside a methodical man that the decision that doesn't need to be made immediately is best left until it does. In 1893, a Pittsburgh company made an offer of $47 an acre, $22,560 in total. She accepted. She divided the proceeds between Clara and James, keeping a portion for herself, that she deposited in the county bank and which she drew on, carefully and in small amounts, for the rest of her life. She lived until 1909, dying at the age of 73 in the house where she had lived since she was 22 years old. She outlived Henry by 19 years and used those years with the same quiet purpose she had used everything else: the farm management, the correspondence, the local church work, the reading she had not had as much time for when Henry was alive. She gave Henry's farm records to the County Historical Archive in 1903, specifying that the leather portfolio be kept with them and not separated. She wrote this specification in a letter, kept a copy of the letter in the portfolio, and filed it there herself before delivering everything to the archive. The leather portfolio is in the county archive now, in an acid-free folder in a box labelled Holloway Farm Records, 1858 to 1909. The solicitor's letters are there. The purchase agreement with Henry's marginal annotations is there. The correspondence with Mrs. Morrow is there. The specification letter in Margaret's handwriting is there. Everything is in order, because order was how both of them had lived, and what they left behind was an extension of how they had lived. Complete, accurate, legible. Outside the archive, in the valley where the farm was, the fields are still farmed. The creek still runs along the south boundary, still reliably through drought years when other streams go dry. The ridge still shelters the valley from the northeast wind. In February, when the ground is frozen and the snow lies flat and the creek is edged with ice, it is possible to stand in that valley in the thin winter light and understand what Henry Holloway was protecting when he wrote his letters in November of 1883 and asked the Pittsburgh solicitor to keep copies. He was protecting the future. He was protecting the person who would be in this valley after he was gone. He had done it with the tools he had. Careful reading, careful writing, careful filing, the leather portfolio on the second shelf, the letters in their envelopes, everything in its place. The smell of a Pennsylvania farm in late summer is difficult to describe to someone who has not lived it. It is not one smell, but many smells arriving simultaneously. The hay drying in the lower field, and the turned earth of the kitchen garden, and the particular warm smell that the wood of the porch acquires when it has been in the sun for several hours, and underneath all of it the smell of the creek, which in August is low enough that you can see the rocks in the bed, and smell the particular mineral coolness that moving water produces when it runs over limestone. Margaret Holloway had known all of these smells for 51 years, which is long enough that they had stopped being smells and had become conditions, things her body registered without requiring her attention. They were simply what August was. Henry Holloway had a quality that Margaret had come to value more highly as the years went by. He made decisions on the basis of evidence and then stood by them without second-guessing. This was not stubbornness. It was the specific confidence of a man who had spent his life distinguishing between things he knew and things he suspected, and things he merely hoped, and who had learned, through long practice, not to confuse the three. When he had read the mineral rights purchase agreement at the kitchen table in September of 1883 and explained each provision, he had done so from a position of genuine knowledge. He had spent 6 months investigating before he made the purchase. He had confirmed the meaning of the ambiguous clause with a professional, and he had then filed the confirmation in the leather portfolio, where it would be available to anyone who needed it. He was not hedging. He was simply being thorough, which was his way of being. The county seat of Caldwell County was a modest town in the western Pennsylvania hills, 7 miles from the Holloway farm along a road that was mud in spring and dust in August and ice in January, and that required a horse patient enough for all 3 conditions and a driver who knew which parts of it to avoid in which seasons. Margaret had driven it hundreds of times over 50 years of farm life, for provisions, for church, for the school board meetings she had attended when the children were young, for the county historical society she had joined in her widowhood, because she found it gave her something to do on Wednesday afternoons that was neither work nor inactivity, which was a balance she had always found useful. She knew the road in its details, the bridge over the tributary that was sound but whose planking needed replacing every 7 years or so, the sharp curve near the Kowalski farm where you had to slow regardless of what the road was doing because the sight line around the corner was insufficient, the long downhill into the county seat where the view opened, and you could see the courthouse dome and the water tower and the line of trees along the main street. Mrs. Addie Morrow's office was on the 2nd floor of a building on Main Street in the neighbouring county's seat, up a flight of stairs that was steeper than necessary, and that creaked on every step, which Mrs. Morrow had always said she found useful as a kind of announcement system. The office itself was large, sunny on the south side, and organised in a way that reflected its occupant's method. Nothing out of place, but nothing sparse. The order of a woman who had too much to do, and had therefore developed systems for doing it efficiently. Her father's law books were still on the shelves, alongside her own, and the combined collection covered 2 walls and overflowed onto a set of shelves that had been added to the east wall sometime in the late 1880s. She had inherited not just the practice but the clients, the reputation, and the files, all of which she had managed with the careful attention of someone who understands that an inherited reputation is both an asset and an obligation. The Pittsburgh solicitor who had handled the original mineral rights transaction was a man named Archibald Vane, retired by the time Mrs. Morrow wrote to him, but still maintaining his files with the professional diligence of someone who has not yet decided how much of his professional identity to relinquish. He had kept the Holloway correspondence because he had been asked to keep it, and because he kept everything he had been asked to keep, in a filing system that his former partner had always described as impenetrable to everyone but Archibald. He found the Holloway file within 2 days of receiving Mrs. Morrow's request, and provided certified copies with a brief note. "I am pleased to confirm that these records have been in my possession since the dates indicated, and have been available for your client's use throughout. I hope they serve their purpose." He signed it with the careful formality of a man who understands that a letter accompanying important documents is itself a document. The manner in which Robert Shin had conducted the estate inventory was, in Mrs. Morrow's assessment, not the result of a careless oversight. An executor who failed to notice an asset as significant as 480 acres of mineral rights was either grossly incompetent or had specific reasons for the omission. Mrs. Morrow did not share this assessment with Margaret, who had not asked for her opinion on the matter and who appeared to have formed her own. She shared it instead with her own professional notes, which she kept in a separate file from the client correspondence, because professional notes are not client correspondence, and she was precise about such distinctions. Her professional notes on the Holloway matter, which she reviewed and updated several times over the following months, were candid in their conclusions and careful in their language, which was the manner of notes written by someone who understands they may be read by others at some point. Margaret had said almost nothing during the May 1890 meeting at Mrs. Morrow's office. She had sat in the chair to Mrs. Morrow's left, which was the client's chair, with her hands in her lap and her expression the expression of someone watching a performance they have already seen. She had identified the pivotal moment of the meeting, when Robert's attorney spoke quietly to Robert for several minutes, and Robert's expression changed from the particular set of a man who expects to prevail to the different set of a man who has just understood that he is not going to. She had watched this change without satisfaction and without surprise. She had known the documents were clear from the moment she had opened the leather portfolio the previous October, and she had held that knowledge through the winter and the spring, through the meetings with Mrs. Morrow and the correspondence with Pittsburgh and the wait for the certified copies, and she had brought it to this room and set it on the table and watched it do exactly what she had known it would do. The correction of the estate inventory was recorded in the county probate records in June of 1890, as was routine. The correction was a brief document in legal language, listing the mineral rights with their description and valuation, and noting their inclusion in the estate of Henry Holloway, deceased. It bore the court's stamp and the date and the signatures of the relevant parties, including Robert Shin's signature, which was required, and which Robert had provided without visible reluctance, because the meeting in Mrs. Morrow's office had made the situation clear. The document lived in the county probate files, where probate documents lived. Margaret received a copy, which she put in the leather portfolio behind the other documents, because that was where it belonged. Clara Holloway married a schoolteacher named Ebenezer Pratt in 1882, and had moved to Ohio when Ebenezer took a position at a school in Columbus. She was a practical woman who wrote letters twice a month and visited the farm twice a year, and who had always had the quality that some daughters have of becoming, imperceptibly and without announcement, more like their fathers than their mothers, which in Clara's case meant that she read documents carefully and asked questions before she signed things. She had read the revised estate inventory with the same attention Henry would have given it, and she had asked Mrs. Morrow several questions about the process and the outcome, and she had been satisfied by the answers. She told Margaret in the summer of 1890 that she thought their father would have found the whole thing straightforward. James Holloway was working his own farm in Caldwell County, 4 miles from the home place, which he had purchased in the mid-1880s with savings from his years of working the home farm and a loan from the county bank that he had paid off in 4 years. He was more like Henry than Clara was, in the specific sense that he did not discuss things he considered settled. He had read the revised inventory, confirmed his understanding of what had been corrected and why, and then gone back to his farm. He would visit Margaret in the autumn to see how the harvest had gone and to drink her coffee, which she made stronger than anyone else in the county, and they would talk about the farm and the price of rye and the condition of the road between his place and hers, and neither of them would talk about Robert Shin or the mineral rights because there was nothing left to say about either. The mineral rights sale in 1893 produced a sum that changed nothing essential about the way Margaret Holloway lived, which was what she had expected. She was not a woman who needed her life to change. She was a woman who needed the record to be accurate, who needed what Henry had left her to be what Henry had intended to leave her, and those things had been accomplished. The money from the sale was a practical matter. It provided security, It allowed her to give Clara and James a portion of what would eventually be theirs without waiting for her own death, and it allowed her to make a modest donation to the county library in Henry's name, which was something she had wanted to do for years and which she now had the means to do. She recorded all of this in the household accounts in her neat hand, because household accounts were the record of what a household was and what it had been, and she'd been keeping them for 31 years and saw no reason to stop. The county library received Margaret's donation in the autumn of 1893. The librarian, a woman named Miss Julia Prout, who had run the library since its founding in 1876, wrote a thank you letter that was longer and more personal than most thank you letters from institutions, because Miss Prout had known Henry Holloway by reputation and considered the donation fitting. She noted that the library would use the funds for the agricultural reference section, which Henry would have approved of, and she noted also that the library was there, should Margaret ever need it, for anyone who wanted to read about mineral rights in Pennsylvania, about which there was apparently quite a good deal to know. Margaret read this letter at the kitchen table on an October morning and thought it was probably the most useful letter she had received in some time. She had begun reading in the widowhood years, which was something she had not had enough time for when Henry was alive, and the farm was the first consideration of every day. She read history, which she found more interesting than fiction, because history was what had actually happened, and what had actually happened was always more complicated and more surprising than what anyone imagined. She read about Pennsylvania, about the Western Territories, about the geological surveys that had driven the mineral rights purchases she had lived through. She read about women's property law, which was available in the county library's reference section, and found it both more instructive and more infuriating than she had expected. She did not discuss this reading with anyone in particular. It was private in the way that reading is private, something she did for her own understanding, her own accounting of the world. In the years after the mineral rights sale, the farm continued in the way that farms continue when they are properly managed, cyclically, seasonally, with the particular rhythm of agricultural life that structures time differently from urban life, by what the ground is doing rather than by what the calendar says. The rye came up in spring and was cut in summer, the hay was cut twice and stored, the creek ran high in April and low in August. The kitchen garden produced and Margaret preserved, and the root cellar filled in the autumn and emptied through the winter. Bernard Kopp worked the lower field and paid his rent on the first of each month, and nodded at whoever answered the door. The household accounts recorded all of it, in the same neat hand, the same careful columns. What the story of Margaret Holloway and the mineral rights documents shows, when you hold it at the right distance, is something about the relationship between knowledge and power in the Gilded Age. The men who dealt in mineral rights had power because they had knowledge. Knowledge of what lay beneath the ground, knowledge of what it was worth, knowledge of how to structure agreements that captured that value. Henry Holloway had gained some of that knowledge through 6 months of investigation, and he had then taken the additional step of confirming his knowledge through professional correspondence and filing that confirmation in a place where it could be found. Margaret had the knowledge because Henry had given it to her, in the most practical way possible, not through explanation but through documentation. The documentation was the knowledge, made permanent, made accessible, made available for the moment when it was needed. This is what Henry had understood when he asked the Pittsburgh solicitor to keep copies. He had understood that knowledge kept only in a single location is fragile, and that the value of knowledge is not in its possession, but in its availability at the moment of need. The mineral rights economy of Western Pennsylvania in the 1880s and 1890s was one of those economic environments that produce wealth rapidly, distribute it unevenly, and leave behind a documentary record that is dense and complicated in proportion to the speed of the wealth's movement. The Holloway farm's lower 40 acres had been sold, partly because Henry had calculated that the mineral development was most likely to occur on the land adjacent to the creek bottom, where the geological formations were more accessible, and partly because the price in 1883 was higher than he expected to receive in any subsequent year, which had proved correct. The farm he retained, the upper fields, the home place, the kitchen garden, the orchards on the south slope, was not mineral rights land. It was land. The mineral rights were a separate investment, properly documented as such. Margaret had learned accounting from Henry, who had learned it from his father, who had learned it from a Scottish farmer who had come to Pennsylvania in the 1790s, and brought with him the view that accounts were not a commercial requirement, but a moral one, You were obligated to know precisely and at all times the state of your affairs, because to not know this was to be, in a specific sense, dishonest, not with others, but with yourself, which was worse. Henry's father had passed this view to Henry, who had passed it to his children, and who had maintained his own accounts in a leather-bound book that he updated every Sunday morning after breakfast and before church, which was the time he had set aside for this purpose, and which he had maintained without exception for 30 years. The November afternoon when Margaret found the leather portfolio was one of the short, dark afternoons of that season, the kind that arrive early and leave early and fill the hours between with a particular quality of dim indoor light that makes a house feel both very close and very quiet. She had lit the lamp on the study desk before opening the portfolio, and the lamp's circle of light on the documents had seemed, in some way she didn't try to articulate, appropriate, a pool of clarity in the dimness. She had read each document carefully in order, as Henry had arranged them. She had read the solicitor's January letter twice. She had read the March follow-up letter once. She had closed the portfolio and sat for a moment in the lamplight and thought about what she had read, and then she had put it back on the second shelf left of centre, where Henry had kept it. Mrs. Morrow's habit of reviewing her cases last thing before leaving for the day had, over 20 years of practice, produced a specific form of professional insight that she recognised as irreplaceable. The late review, when the day's urgency had passed and the office was quiet, allowed her to see patterns she missed in the active hours, the thing a client had said that seemed ordinary at the time but that, in retrospect, was the pivot of the whole matter, the document that was present but hadn't been given sufficient weight, the question that hadn't been asked. In the Holloway case, the late review had produced one particularly useful observation. The March follow-up letter from the Pittsburgh solicitor, which she had initially read as a routine confirmation of the January letter's conclusions, was actually something slightly different. It was the solicitor's record that he had been asked to keep copies in his own files, which meant that the evidence of what Henry had intended was not held solely by the Holloway estate. It was held in Pittsburgh as well, by a man who was still alive and still practising, and who would, if asked, provide certified copies of documents that had been in his possession since 1884. The creek along the south boundary of the farm ran higher in spring than at any other time, swollen with snowmelt from the hills and with the accumulated rainfall of March and April, and in those weeks it was audible from the farmhouse on still mornings. A low, continuous sound, not loud but persistent, the sound of water that has somewhere to go and is going there without urgency. Margaret had fallen asleep to this sound every spring of her adult life. In the spring of 1890, after Mrs. Morrow had written to Pittsburgh and before the certified copies had arrived, she lay awake on several evenings listening to the creek and thinking about what Henry would have said about the situation. She knew what he would have said, which was why she was not afraid of the outcome. He would have said, "The documents are clear. We confirmed them. I kept the copies. Go and get them." The word mineral rights carried, in 1890, a weight of recent and rapidly changing meaning. 10 years earlier, the term had referred to a relatively modest category of property interest, the right to extract limestone, gravel, perhaps coal in the eastern counties. By 1890 it had expanded in common usage and in legal practice, to include the petroleum deposits that had been transforming the western Pennsylvania landscape since the Drake Well in 1859. The rights to what lay beneath a farm in 1890 might mean nothing at all, or they might mean a substantial sum arriving seasonally for decades. Henry Holloway had understood this when he made the purchase in 1883, which was why he had investigated before purchasing and confirmed the purchase agreement's terms with professional advice. Robert Shinn's calculation, whatever it was precisely, had a specific flaw. He had assumed that the knowledge of what Henry had intended was confined to Henry, and that Henry was no longer available to clarify his intentions. This was the category of error that people make when they fail to account for documentation, the assumption that what a person knew died with them. Henry Holloway had not left his intentions unrecorded. He had left them in a leather portfolio, and he had left copies of the confirmatory correspondence in Pittsburgh, and he had given Margaret every reason to find and use both. He had not done this because he anticipated the specific situation that arose after his death. He had done it because he was a thorough man who understood that records are what survive, and that what is worth knowing is worth confirming and worth filing. There is something about the image of Margaret Holloway in the May 1890 meeting, sitting beside Mrs. Morrow at the table, watching Robert's expression change as the documents were laid before him, that captures something essential about what records make possible. She was not wealthy. She was not politically powerful. She was a widow in her early 50s, in a period when widows of her station were expected to accept the interpretations offered to them by the men managing their affairs. She was none of those things. She was a woman who had, through no particular effort of her own, only the effort of having a thorough husband who had kept his records in a specific place, exactly the documents that made her position unambiguous. This is not a story about exceptional intelligence or exceptional courage. It is a story about the ordinary value of ordinary records, kept thoroughly, kept in a consistent place, and available when they were needed. The creek still runs along the south boundary of what was the Holloway farm. The farm itself has changed several times in ownership since Margaret's day, but the land is still farmed, and the creek still defines the south line, and in April, when the snowmelt comes down from the hills, it still runs high and audible from the farmhouse, that low continuous sound that Margaret fell asleep to for 50 years. The mineral rights, the 480 acres below the surface of the lower field, were developed in the 1920s and had largely ceased producing by the 1940s, which was the ordinary life cycle of a Western Pennsylvania mineral lease in that era. The surface farm continued as surface farms do, indifferent to what had been extracted from beneath it, and replaced with the slow work of agriculture that had always been the farm's primary identity. The accounts that Margaret kept, the household ledger that recorded all of it, passed with the farm when she died in 1907, and were eventually lost in the way of farm records when farms change hands. Not deliberately destroyed, but simply not carried forward, not considered worth the space. The leather portfolio was different. It was held by the family, and it is in an archive now. Every housekeeper of any competence kept a ledger. This was not personal preference, but professional necessity. There were household accounts to track, tradesmen to pay, provisions to inventory, the wages of any additional staff to record, the household coal supply to monitor against the coal merchant's bills, the linen against the laundry. A ledger was the evidence of professional order. It was also, in houses where the domestic management was complicated, the memory of the house itself, the record of what had been spent and on what, of what had been decided and by whom, of the arrangements that kept a household functioning despite the fact that households are always, in some fundamental sense, arrangements against entropy. Agnes Fairfax had kept her ledger for 31 years. It was not until the autumn of 1904 that it became the most important document in a probate proceeding in the Eastern District of Massachusetts. She had come to the Langford house in 1873 when she was 26 years old, and the house was in a state of considerable disorder. The disorder was not moral or personal, which was the kind of disorder she would have refused to manage. It was simply domestic, the specific state of disorganization that occurs when a widowed professor who has been managing his own household for 2 years has found himself unequal to the task. Arthur Langford was 61 years old when Agnes came to the house, and he had been a professor of natural philosophy at the college for 30 years, and in those 30 years his wife Caroline had managed the domestic side of his life with such completeness and such competence that he had largely not noticed it was happening. Her death in 1871 had been, for Arthur, a grief he would have described as primarily emotional, but which proved to be substantially logistical as well. The house had 12 rooms, it required careful management. He had employed 3 different housekeepers in 2 years, none of whom had stayed more than 3 months. The most recent had left in February, giving no specific reason, but the reason was visible in the state of the kitchen and the linen cupboard and the greenhouse, where 3 of the tropical specimens had died in January for want of proper humidity maintenance. Agnes had learned about the position through the network of domestic employment that ran through every Protestant church in Boston at that time. A minister had mentioned it to a deacon, who had mentioned it to his wife, who had mentioned it to her cousin who knew Agnes. She had come to interview on a Tuesday in March, taking the horse car from the South End where she was living in a boarding house, while she looked for a position. The Langford house was in Brookline, which required a transfer and a walk of several blocks from the car stop, and she had arrived at the front door slightly out of breath and with the spring mud of Brookline still on her boots, which she cleaned on the boot scraper before knocking, and which she was aware of having cleaned, though the boots themselves were still dusty rather than clean after this treatment. Arthur had answered the door himself, which was the first indication that the house was in the state she had been warned about. Employers who had their domestic arrangements in order did not answer their own doors. He was a tall man, slightly stooped in the way of men who have spent decades bending over desks with white hair and the particular vagueness of expression that belongs to people whose attention is usually on something other than what is directly in front of them. He looked at Agnes with what might have been a mixture of hope and uncertainty, and he invited her in, and she followed him down a hallway where the floor needed sweeping and through to the kitchen, where it needed considerably more than sweeping, and she looked at the kitchen and felt the quiet, purposeful satisfaction of a person who is looking at a solvable problem. The interview lasted 40 minutes. Arthur asked her about her previous positions, her experience with complicated households, her approach to the greenhouse, which was, he said, very important to him professionally. Agnes asked him about the specific requirements of the tropical specimens, about the condition of the kitchen equipment, about his expectations regarding household staff, and about what had specifically gone wrong with the 3 previous housekeepers. She asked this last question directly and without apology, and he answered it, also directly, by listing in order the 3 areas where each woman had found the job's requirements unsatisfactory. This told her a great deal about both the position and about Arthur Langford, who was clearly a man who had thought about what had gone wrong and had formed conclusions about it rather than simply feeling aggrieved. She accepted the position. She moved in on the 1st of April, arriving with 2 trunks and a hatbox and the cloth-bound ledger she'd been using for household accounts since her first position at the age of 18. The ledger was her professional tool, her record, her primary method of keeping order in the chaos that domestic life perpetually generated. She began entries on April 2nd, the inventory of household provisions, which she had conducted on the afternoon of April 1st, going through every cupboard in the kitchen and the pantry with a candle and a paper and pencil, the coal supply, the condition of the linen. She noted what needed immediate ordering, what could wait, what needed repair. She noted also the state of each of the tropical specimens in the greenhouse, which she had visited at 7 o'clock on the morning of April 2nd with Arthur at her elbow, and she recorded her assessment of each plant's condition and what it required. She did this because Arthur had asked her to, but also because she understood, from the interview, that the greenhouse was the heart of the house's professional purpose, and that the heart required careful monitoring. Over the following 31 years, the ledger accumulated the life of the Langford household the way that certain kinds of records accumulate the lives they document, not dramatically, not selectively, but in the daily way of something that is kept up without interruption. Agnes recorded everything that required recording: the accounts, the provisions, the staff wages, the maintenance and repair work done and by whom, the correspondence with tradesmen, the condition of the greenhouse and its changing requirements as the collection of specimens grew, and as Arthur's research evolved. She recorded the doctor's visits when Arthur was unwell. She recorded the visits of his 3 nephews, Ellsworth and Donald and Walter, who came at irregular intervals and stayed for variable amounts of time, and whose arrivals and departures she noted in the way she noted everything else that affected the household's functioning, as facts without opinion. Arthur Langford was a good employer in the specific sense that matters most in domestic work. He was clear about what he required, he was satisfied when those requirements were met, and he did not move the goalposts or invent new requirements when existing ones were fulfilled. He was, in the domestic sense, reliable. He also had, in Agnes' estimation, a quality that was rarer than reliability. He was genuinely attentive to what the household required and what she did to meet those requirements. Not in the sentimental sense that employers sometimes develop toward long-serving staff, a vague, affectionate regard that is comfortable for the employer and slightly suffocating for the employee. He paid attention in the practical sense. He noticed when the greenhouse specimens were properly managed. He noticed when the accounts were balanced with particular accuracy. He noticed when the household ran with the particular smooth invisibility that very good domestic management produces, where the mechanism disappears into its function. Over 31 years, this professional respect had become something that both of them would have found difficult to name, but that both of them recognized. It was not friendship in the sense that either of them would have described as friendship. It was not the vague paternalism that could develop between an employer and a long-serving domestic. It was more like the relationship between 2 people who have worked in the same building for a very long time and have developed, through daily proximity and through the accumulated evidence of each other's professional competence, a mutual regard that is specific and grounded and that doesn't require categorization to be real. In 1895, Arthur Langford went to see his solicitor, Mr. Cyrus Hale, and revised his will. He had been thinking about it since the previous winter, when a colleague at the college had died and left his housekeeper of 20 years nothing but a letter of reference. Arthur had found this inadequate and had said so, at the college's memorial dinner, in terms that had made the colleague's surviving relatives uncomfortable. He went to Hale's office in March and had a conversation that was, by Hale's account in his own file notes, both clear and practical. Arthur wanted to leave $10,000 to Agnes Fairfax outright, and he wanted to provide her with the right to remain in the Langford house for 5 years following his death, at which point the house would pass to his nephews as the earlier will had always specified. Hale drafted the provision with the care he gave all testamentary bequests: full name, Agnes Mary Fairfax, the sum in both numerals and written words, the duration of the residence right, the conditions under which the right would apply. He added to his own file copy a brief notation in his margin. Bequest to long-serving housekeeper, Professor indicated particular regard for her management of household and greenhouse specimens, approximately 22 years' service to date. He filed the revised will with the County Probate Court on the 12th of December, 1895. He registered the copy with the client file. He sent Arthur a registered copy. Arthur brought it home and put it in the library, in the drawer of the reading desk under the carbon paper and the pen wiper. Agnes did not know about this. She was not told, and she would not have thought to ask. She managed the household. She maintained the ledger. She cared for the greenhouse specimens, which had grown in number and in complexity over the 22 years she had been managing them, until the greenhouse in winter required more careful attention than the kitchen. Specific humidity levels for the tropical plants that could not tolerate the New England cold even in the glass and iron structure that Arthur had built in 1881. Particular light management through the short days of December and January. A routine of inspection that she had developed gradually over the years and had written up in the back pages of the ledger in a notation system she had developed for herself that recorded what each plant required and when it had last received it. Arthur's health began to decline in 1901. It was not one thing, but the accumulation of several. The heart that was less reliable than it had been, the back that had finally objected to decades of hunching over a laboratory table, the general fatigue of a man of 80 who has been working consistently for 60 years. The decline was gradual and then more rapid, and Agnes managed the household through it with the same steady attention she had given it in the years when Arthur was working full days at the college and needed the house to function without his supervision. She managed the doctor's visits, the medicines, the requirements of a sick room that was simultaneously a working library. She maintained the greenhouse through his decline because he had asked her to. She handled the correspondence with the college about his remaining obligations because someone had to, and she had been doing it informally for several years. The nephews came more frequently as it became clear that Arthur was approaching his last year. Ellsworth, who was the eldest and the attorney, came from Boston. Donald came from Providence. Walter came from Beacon Hill. They were attentive to Arthur in the visiting way of men who have good intentions and limited time, and who express their concern through the occasional afternoon visit and the periodic inquiry into the estate's arrangements. Agnes managed their visits as she managed everything else that affected the household's functioning. She provided tea and biscuits. She answered questions about Arthur's condition and medication schedule. She gave them access to Arthur when the doctor permitted visitors and tactfully managed the timing when he didn't. She noticed over the course of these visits that Ellsworth had a particular interest in the library. He spent time there when he came, going through Arthur's professional correspondence, reviewing the books. This was not necessarily suspicious. Ellsworth was the executor, and the library was a significant portion of the estate's contents. But Agnes noticed it in the way she noticed everything about the household, as information to be filed and retained. Arthur Langford died in October of 1903. He was 81 years old, and he had been declining consistently for 2 years, and when the end came it was, as these things sometimes mercifully are, quiet. Agnes was in the kitchen when it happened. The doctor came. The nephews were summoned and arrived within the day. The house became briefly full of the specific activity that surrounds a death, the doctor's formalities, the undertaker's arrangements, the notifications, the neighbours and colleagues who came to express their condolences. Agnes managed all of this in the same way she had managed the house for 31 years, efficiently, without requiring recognition, without dropping anything. After the funeral, the nephews met in the library. Agnes brought tea and set it on the table and left the room. She did not attend to what was being said because housekeepers do not listen to conversations they are not invited to be part of. What she noticed, when she returned for the tray, was that Ellsworth did not meet her eyes. Over the following 2 weeks, the nephews occupied the house in rotation, going through Arthur's correspondence and books and papers, which was a legitimate part of estate administration, and which Agnes did not resent. What she did notice was the particular care with which they managed the process. Documents moved from one room to another. Boxes were packed and labelled in Ellsworth's hand. The library was organised and reorganised in a way that made its original order increasingly difficult to reconstruct. She noted all of this in the ledger, not in the household accounts section, but on the blank pages at the back. Dates, times, what she had observed, written in the same neat hand she used for the greenhouse notes. In November of 1903, 3 weeks after Arthur's death, Ellsworth came to the kitchen and told Agnes that he had reviewed the will and that while she was welcome to remain in the house for a reasonable period to arrange her affairs, the will as filed did not appear to include any specific provision for her. He said this gently, with the gentleness of a man who has prepared the delivery of bad news and finds that the preparation has made him feel better about it than the situation warrants. He said the nephews would be happy to provide her with a letter of reference. He asked with real courtesy whether she had any questions. Agnes thanked him. She offered him a piece of the ginger cake she had made that morning, and he accepted it. He left satisfied, as men who have delivered difficult news and met with no immediate resistance often are. Agnes sat at the kitchen table after he left. She thought about the will, about Mr. Hale's office, about the registered copy that Arthur had put in the library drawer. She thought about the library drawer, which was under the carbon paper and the pen wiper. She had cleaned that room every Wednesday for 31 years. She had restocked the carbon paper from the stationers on at least 3 separate occasions. She knew the contents of that drawer the way she knew the contents of every drawer in the house, by proximity and repeated contact, by the accumulated knowledge of a person who has been in a room regularly for a very long time. She went to the library. The drawer was not locked. Arthur had never locked it. Agnes opened the drawer and moved aside the carbon paper and the pen wiper, and found the registered copy of the revised will, its envelope still sealed with Arthur's sealing wax, still stamped by the county probate court with the December 1895 filing date. She took the will to the kitchen table. She read it carefully, sitting in the morning light that came through the kitchen window, the familiar smells of the house around her. The provision for Agnes Mary Fairfax was in the 3rd page, 4th paragraph, clearly worded, correctly drawn. $10,000 outright, the right to remain in the house for 5 years. She read it twice, not because she had doubted it would be there, but because she wanted to be precise about what it said before she said anything to anyone. She also found, in the same drawer, a letter from Arthur to Mr. Hale dated September of 1895, in which Arthur had written, "I am writing to request that you note, for your records, the full and clear nature of my intentions with respect to the bequest to Miss Fairfax, and that you retain this correspondence in the event that any future question arises about its validity." Arthur had known. He had known that a housekeeper's bequest might be challenged. He had prepared for it in the same way he had prepared for everything, by writing to the appropriate person and asking them to keep a copy. Agnes placed the will and the letter in her ledger. Then she also removed from the pocket inside the back cover of the ledger a receipt she had obtained from Mr. Hale's office in December of 1895, when she had gone to return a library book that Arthur had borrowed and forgotten to return. She had stopped at Mr. Hale's office on the same errand and had asked, on impulse, whether Mr. Hale could confirm that Arthur's will had been properly filed. Mr. Hale had confirmed it, and he had given her a dated receipt of the filing. She had put the receipt in the back of the ledger because she believed in having things in writing, and because 31 years of household management had given her a deep intuition about which pieces of paper were important. She went to see Mr. Hale the following Monday. She brought the ledger, the registered copy of the will, and the receipt. Mr. Hale, who was a decent man and who had been expecting something of this kind, was not surprised to see her. He confirmed that the will as Agnes held it was the current and valid document. He confirmed that it had been filed on the 12th of December 1895, and had not been superseded by any subsequent document. He said, with the careful hesitation of a man who does not wish to make accusations he cannot yet support, that he was unable to account for how Ellsworth Langford had reviewed the will without identifying the provision for Agnes. Agnes said she thought Mr. Hale might want to contact Ellsworth's attorney directly. She returned to the house. The rest proceeded through the proper channels, which are slow and produce considerable correspondence, and eventually produce an outcome. The probate court reviewed the will as filed. The provision for Agnes Fairfax was confirmed. The court inquired into how the estate inventory had been prepared without reference to this provision. Ellsworth's explanation, which cited an inadvertent review of an outdated draft rather than the filed document, was accepted without further comment. Agnes received her $10,000 in the spring of 1904. She remained in the Langford house for the 5 years the will specified, maintaining it with the same care she had given it since April of 1873, the accounts, the greenhouse, the provisions, the coal, the linen. When the 5 years were complete and she left the house in the autumn of 1908, she took the ledger with her. She took it to the small house she purchased in Cambridge with her savings and the bequest. She placed it on the desk in the front room and continued to use it. The Cambridge house was smaller and simpler than the Langford house, and its accounts were correspondingly simpler, but Agnes kept them with the same thoroughness she had given to 31 years of a complicated household. She kept the greenhouse notes too, even though she had no greenhouse of her own. She grew plants on the south windowsill of the front room, modest things, nothing tropical, and she recorded what they required and when they had last received it in the same notation system she had developed in the Langford greenhouse, because the system worked and there was no reason to stop using a system that worked. She lived in the Cambridge house for 18 years after she left the Langford house. She died in 1926 at the age of 79 in the front room of the small Cambridge house, where the south window held the light she had relied on for her window plants, and where the desk held the ledger that had been her professional companion for 53 years. Her niece came to settle the estate, and found the ledger still in use. The last entries in Agnes's handwriting, noting the price of coal and the date of the plumber's last visit, and the amount she had given to the church collection in October. The niece kept the ledger. She had heard the story of the Langford estate and she understood what the ledger was. Not merely a household record, but the evidence of a particular kind of attention, the proof of a professional life conducted with exactness and without self-congratulation. She kept it in the desk in her own house, in a drawer, where it remained for many years in the category of things that are too important to discard but too specific to use. It is perhaps still somewhere, in someone's desk in some drawer, in the particular silence that old ledgers acquire when they are no longer being written in but are still being kept. Outside the Cambridge house, the evening is coming in over the common. The street lamps are lit. Through the front window, if you were walking by and paused to look in, you would see the desk lamp making a warm rectangle on the street, and you would see the ledger on the desk and you would understand nothing specific about it, because ledgers do not explain themselves to passers-by. What they do is hold what was written in them: the coal price, the plumber's visit, the church collection, the greenhouse humidity records, the provisions accounts for 31 years of a complicated household, the receipt from Mr. Hale's office, dated December of 1895, that was in the back pocket of the ledger when everything else was needed. Everything that matters, in its place, exactly where it was put. The greenhouse at the Langford house occupied a structure that Arthur had commissioned in 1881, replacing an earlier, smaller conservatory that had housed a modest collection of indoor plants in the conventional Victorian manner. The 1881 greenhouse was different in kind, a purpose-built glass and iron structure on the south side of the house, with a heating system separate from the main house's furnace, and with the specific orientation and glazing that Arthur's professional requirements demanded. It needed to maintain consistent temperatures through a New England winter, which was not a modest requirement. It needed specific humidity levels for the tropical specimens, which required a regime of careful management throughout the year and particularly in the cold months when the heating system was running and the air was naturally dry. Agnes had learned these requirements from Arthur over the first years of her tenure, and she had written them down. The tropical specimens had been collected by Arthur over decades of professional connection with botanical gardens in the United States and in England, and they represented specific research interests that had, by the time Agnes came to the house, become both professionally significant and personally attached. There was a collection of orchids from Central America that Arthur had been growing since the 1860s, and that had, under his care and then under Agnes's, developed into specimens of unusual size and health. There was a group of ferns from the Pacific Northwest that had been sent to him by a colleague at the University of California and that required shade management in addition to humidity management. There was a single specimen of a Madagascan palm that was, as far as Arthur knew, the only one growing under glass in New England, and that he referred to in his notes as the Admiral, after the naval officer who had brought the original seed from Madagascar in the 1850s. Agnes had learned to care for the Admiral with particular attention. It was not a forgiving plant. It needed specific light, specific water, specific temperature ranges that were narrow enough that a week's inattention in January could set it back months. She had been monitoring it since April of 1873, recording its condition and requirements in the back pages of the household ledger, and by the time Arthur's health began to fail, she had been caring for it for 30 years. When Arthur died in October of 1903, her first concern after the immediate domestic management of a death in the house had been the greenhouse, which needed attention regardless of what was happening elsewhere. She had gone out at 7 o'clock in the morning of the day after Arthur's death to check the temperature and the humidity, and to water the specimens that needed watering. The Admiral was fine. It had, she noted in the ledger, put on 3 new leaf buds that month. The relationship between a good housekeeper and a house is different from the relationship between a homeowner and a house, which is a relationship of ownership. It is also different from the relationship of a tenant, which is a relationship of temporary occupancy. It is something more like the relationship of a caretaker, someone whose responsibility is to maintain what they manage in the condition in which they found it, or better, and to hand it on in that condition to whoever comes next. Agnes had always understood her work this way, as stewardship rather than either ownership or occupation. She was responsible for the house, for the greenhouse, for the records of both. She was not responsible for them in the sense of possessing them, but in the deeper sense of understanding their requirements and meeting those requirements consistently, day after day, year after year, without requiring recognition for the continuity that this consistency produced. The 31 years of the household ledger were not in themselves unusual. Many housekeepers of Agnes's experience and capability kept records of similar scope. What was unusual was the completeness and the continuity. Not a single year missing, not a single month unaccounted for, the record beginning in April of 1873 and continuing without interruption through October of 1903, when Arthur died and the household changed character. The completeness was not the result of extraordinary discipline, it was the result of habit. Once she'd begun keeping the ledger, stopping had not seemed like an option. The ledger was how she knew where she was, in the same way that a navigator uses a chart, not to replace observation but to locate it, to give the ongoing experience of the work its accumulated context. The receipt from Mr. Hale's office was perhaps the most individually consequential single document in the whole assembly that Agnes brought to Mr. Hale in November of 1903. The ledger and the registered copy of the will together were enough to establish that the bequest existed and was valid. But the receipt, dated December 1895, confirmed something additional, that Agnes had been aware of the bequest's existence and had taken steps to verify it at the time, which established that the bequest had not been added to the will after Arthur's death, and that the registered copy Agnes held was not a recent fabrication. The receipt was the context that made the rest of the documents unambiguous. It was also, ironically, the document that Agnes had obtained most casually. She had stopped at Hale's office on an errand, asked a question, and put the receipt in the back of the ledger because she had the habit of filing things. Arthur Langford's relationship with the college had been the defining context of his professional life, and the college had been the context of much of what Agnes had managed in the house. The correspondence with colleagues, the preparation for lectures, the particular schedule of the academic year that determined when the house was busy and when it was quiet. All of this had been the background against which the household had operated, the frame within which Agnes had managed the kitchen and the greenhouse and the accounts. After Arthur's death, the college had written to Agnes to inquire about the fate of his research notes, which were of interest to the natural philosophy department. She had replied that the notes were in the library and that the estate's administrator would be in touch about them. She had filed the college's letter in the correspondence file for 1903 under Colleges Institutions, which was the category she had established for institutional correspondence in 1880. Ellsworth Langford's manner with Agnes had always had a quality that she found difficult to name but easy to recognise. The manner of a man who is quite certain of the relative positions of the people in a room, and acts accordingly without quite admitting that that is what he is doing. He was not rude to her. He was not, in any specific exchange, dismissive. He was simply consistently positioned in the conversation such that she was the domestic and he was the relative, and this positioning was so habitual that she suspected he performed it without conscious intention. She had observed this over the years of his visits to the house, and had filed it in the same part of her understanding that she filed other things that might become relevant, noted, retained, not acted upon until action was required. When she went to the library on the morning after Ellsworth had told her there was no provision in the will, she found that the drawer under the carbon paper and the pen wiper was locked. This was the only drawer in the house that Arthur had locked during his lifetime. Arthur had not been a secretive man. His private correspondence, his research notes, his financial papers were all in drawers and files that he had given Agnes access to without qualification, because she needed access to manage the household and because he trusted her. The library drawer under the carbon paper and the pen wiper had been the exception. He had locked it because it contained the registered copy of the will, and he had told Agnes, when she had once noticed the lock and asked about it, that it contained something that ought not to be disturbed. He had not said what. She had noted this, with the understanding that if she ever needed to know what was in the drawer, she would find out at the appropriate time. What Agnes had not told Ellsworth when he came to give her the news about the will was that she knew the drawer. She knew where Arthur kept the key. She knew this because she had been in the library every Wednesday for 31 years, and Arthur had been in the library most of those Wednesdays as well, and the key had lived in a specific location that she had noted because she noted specific locations as a matter of professional practice. The key was in the pen tray on the left side of the desk surface under the letter opener. She had not opened the drawer during Arthur's lifetime because she had no reason to, and because respecting the locked drawer was part of respecting Arthur's arrangements. She had no hesitation about opening it after his death, because Arthur's arrangements included the bequest, and the bequest was the thing the drawer was protecting. The 5 years that Agnes remained in the Langford house after Arthur's death were the quietest years she had known there. The Nephews managed the estate at a distance. The greenhouse remained her primary concern, and she managed it through the 5-year period with the same attention she had given it through Arthur's lifetime. The Admiral put on additional leaf buds in 1904 and flowered for the first time in 1906, which Arthur had always said it would eventually do if it was properly cared for. Agnes noted the flowering in the ledger with particular detail, the date, the number of flower spikes, the colour of the blooms, which were a deep reddish-brown that no printed description had adequately prepared her for. She noted that she thought Arthur would have been pleased. When Agnes left the Langford house in the autumn of 1908, she arranged for the tropical specimens to be transferred to the care of the botanical garden at the college, which Arthur had originally hoped for, and which she had been corresponding with since the spring. The Admiral went with the rest in a specially prepared transport arranged by the botanical garden's curator, who had been corresponding with Arthur about the Admiral for 15 years, and who received it with the particular reverence that botanists reserve for specimens whose history they know. Agnes signed the transfer document and kept a copy, which she filed in the ledger under the greenhouse notes for 1908. She noted the date of the transfer, the name of the receiving institution, and the condition of each specimen at the time of transfer. All in good health, she wrote, all properly maintained. The small house in Cambridge was on a street of similar houses, each with a south-facing front room, each with a garden that in summer grew whatever its occupant chose to grow, and in winter went dormant in the polite English manner that Cambridge gardens favoured. Agnes grew herbs on the south window-sill, in pots that she managed with the same attention she had given the tropical specimens, though at less demanding humidity levels. She also grew, in the back garden in summer, a kitchen garden of modest scope, tomatoes against the south wall, cucumbers on a frame, parsley and chives and the mint that grew without encouragement in a way that would have required encouragement to stop. She noted all of this in the Cambridge ledger, which was the continuation of the Langford ledger, using the same notation system, the same handwriting, the same careful column format for the household accounts. There is a kind of knowledge that only comes from very long proximity, not the knowledge of facts, which can be acquired quickly, but the knowledge of character, of how things behave over time, under different conditions, in the range of circumstances that long experience provides. Agnes had this knowledge of the Langford house, of its greenhouse, of its records. She also had it, by extension, of the people who had occupied it: Arthur and his professional habits, the Nephews and their visiting patterns, the tradesmen and their reliability. This knowledge was the deeper product of the ledger, more important than the individual entries. The entries were data. The knowledge was what you developed when you had enough data about the same things over long enough to understand what the patterns meant. Mr. Hale, when he received Agnes in November of 1903, had been practicing law in Brookline for 35 years. He had seen many estate disputes. He had seen many situations in which a provision of a will had been, through one mechanism or another, made less visible than the testator had intended. He had not seen, in 35 years, a situation in which the evidence assembled by a housekeeper of long service had been as complete as what Agnes set on his desk that November morning: the registered copy, the letter from Arthur requesting formality, the receipt confirming the filing date, and the ledger covering 31 years of the household's life. He had looked at it all for a long time before he looked up at her and said that the matter seemed clear. She had said yes, she thought it was. They had proceeded from there. The natural philosophy department of the college had accumulated, by the time Arthur Langford joined it in 1872, a tradition of botanical research that went back to the college's founding. Arthur had joined the tradition and had contributed to it for 31 years, and his specific contribution, the care and documentation of tropical specimens under glass, and the methodology he had developed for maintaining consistent growing conditions in New England, had become a reference in the field. His papers had been read in London and in Boston, and in the botanical gardens of Philadelphia, and his correspondence file with colleagues at those institutions was substantial. Agnes had managed his correspondence for 31 years. She knew which institutions he wrote to regularly and which had written to him, and she had a clear sense of the professional network that had developed around his work, because the network's maintenance had been partly her responsibility. The library at the Langford house was one of those rooms that accumulate character from use over very long periods. The books on the shelves were not decorative, they were the working library of a professional naturalist, arranged by the logic of the work. Taxonomy on one wall, regional flora on another, geological surveys on a third, and the particular sprawling section of botanical theory and methodology that had always resisted neat categorization and had been shelved, over 30 years, according to a principle that Arthur understood and Agnes had gradually come to understand, and that would have been opaque to anyone who had not worked in that room. The desk at the centre was a large partner's desk that had been in the room since before Agnes's time, and that had accumulated, over the decades, the small modifications of long use: the worn spot on the left edge where Arthur rested his forearm when he wrote, the ink stain on the right corner from a bottle overturned in 1884, the brass handles on the drawers worn bright by repeated handling. What Agnes had understood, in the years after Arthur first told her about the will and the bequest, was that his reason for the registered copy was practical rather than sentimental. He had said, in the conversation she remembered clearly, they were in the greenhouse in February, checking on the specimens after a week of particularly cold weather, that a housekeeper's interests were not always treated with the seriousness they deserved, and that the registered copy ensured that the provision would be discoverable, regardless of what happened to the document held in the house. He had said it in the matter-of-fact tone he used for professional matters, not as a warning about anything specific, but as an explanation of methodology. He was the kind of man who explained his methodology, which was, Agnes had always thought, why the methodology usually worked. She had kept the receipt in the back pocket of the household ledger not because she had specifically anticipated needing it, but because she kept receipts in the back pocket of the household ledger, and because the receipt was a document relating to household business. The category of business was not the kind she usually dealt with: provisions, maintenance, staff wages, accounts settled, but the filing logic applied regardless of category. A document relating to the household went in the household ledger. The receipt went in the household ledger. 31 years later, when Mr. Hale asked her if she had any documentation of when she had visited his office, in 1895, she removed it from the back pocket and set it on his desk, and it said exactly what it said, and the conversation continued from there. The Cambridge house where Agnes spent her remaining years was a modest house on a modest street, and she was a modest woman in most of the ways the word is used, except that she was not modest about her work, which she understood clearly and assessed accurately. She had been a very good housekeeper. She had kept the Langford house in excellent order for 31 years, had managed the greenhouse through 15 seasons of difficult New England winters, had maintained records that were complete and accurate, and that had proved, at the one moment when their completeness and accuracy were relevant beyond the household's own purposes, to be exactly adequate to that purpose. She did not consider this an accomplishment requiring celebration. She considered it the natural result of doing the work correctly for a long time, which was what she had been employed to do. The question of what a housekeeper of 31 years is owed by the estate of the person she served is a question that Gilded Age law answered imperfectly and inconsistently. A bequest in a valid will was enforceable, but a bequest in a will that had been mislaid, or misfiled, or in some way made difficult to produce, was vulnerable to the kind of denial that Ellsworth Langford had attempted. Not a direct challenge to the will's validity, but a claim that the relevant provision didn't exist, or couldn't be found, or was perhaps in an older draft that had been superseded. The vulnerability of such bequests was proportional to the housekeeper's ability to establish, independently, that the will existed and what it said. Agnes could establish this. Her receipt from Hale's office in 1895 was the document that made the registered copy's existence unassailable. It proved that she had known about the registration at the time of registration, which meant the registration was a fact in existence then, not a recent manufacture. Arthur Langford's letter to Hale requesting that the formality be observed, because the interests of a housekeeper are not always treated with the seriousness they deserve, was a sentence he had written after observation, and with intention. He had seen, in the cases of colleagues and in the general newspaper record of the period, what happened when domestic employees' interests in an estate were left to the goodwill of those administering the estate. He had not assumed goodwill would be sufficient. He had assumed, accurately, and that documentation would be necessary, and he had taken the steps that documentation required. His foresight was not extraordinary. It was the ordinary foresight of a methodical man applying to a personal situation the same care he applied to his professional research, identifying what was uncertain, taking reasonable steps to resolve the uncertainty, filing the evidence of those steps in a place where it would survive him. Agnes went on with the household after the matter was settled. That is the correct phrase for what she did. She went on with it. She continued to wake at 6:30 to begin the kitchen preparations, to manage the supplies and the accounts in the greenhouse, to record everything in the ledger. The settlement of the legal question had not altered the household's requirements. The Admiral still needed its temperature managed. The orchids still needed their humidity level. The records still needed to be kept. She kept them. The 5 years she remained in the house after Arthur's death were, in their daily texture, not very different from the 31 years before. The difference was not in the daily texture. The difference was in what the future held, which was the small house in Cambridge, the kitchen garden, the continued ledger now covering a different household, the provision that Arthur had made and that the documents had secured. She thought about this sometimes, in the greenhouse in the winter afternoons, checking the temperature and the Admiral's latest growth and writing the notes in the ledger. She had been taken care of. The records had taken care of her. It amounted to the same thing. Sleep finds the people who have set their affairs in order. Not because order produces ease, the ordered life has its full share of difficulty, but because order produces clarity, and clarity produces over time a particular quality of rest that comes from knowing where things stand. Agnes knew where things stood. She had known since November of 1903, sitting in Mr. Hale's office with the documents on the desk between them, that the record was clear. The ledger was clear. The will was clear. The receipt was clear. What needed to be known was knowable. She had slept well that night, in the house she had managed for 31 years, and she would sleep well in Cambridge, and the Admiral would continue to grow toward its flowering, and the records would be there in the morning. In the autumn of 1913, a quitclaim deed appeared in the county records of a Virginia county bearing the signature of Eleanor Braddock, dated the 14th of March, 1912. The deed transferred a 12-acre orchard and the farmhouse that stood at the edge of it from Eleanor Braddock's personal estate to the Braddock Family Land Trust, administered by her nephew Lawrence. Eleanor Braddock had not signed it. On the 14th of March, 1912, Eleanor Braddock had been in bed with a fever that her doctor had described, in his casebook entry for that date, as severe influenza complicated by a secondary chest infection, and she had not left her room, let alone the house, for 11 days in either direction. This was not a fact she had to establish through recollection. It was a fact she had written down, every morning and every evening, in the diary she had kept without interruption for 47 years. The Braddock family had been in Albemarle County, Virginia, since the 1790s, which was long enough that the family name had become, in certain parts of the county, less a surname than a description of a landscape. There was Braddock's Ford on the river, where the crossing had been reliable since before anyone living could remember, and where the footing was good, even when the water was running fast because the rock bottom there held without shifting. There was the Braddock Oak at the edge of the Waynesboro Road, which some people said was 300 years old and others said was 150, and both groups were probably wrong, but the tree was enormous in the way of things that have been growing without interruption for a very long time, its trunk requiring the arms of 3 people to encircle, its canopy covering a circle of ground beneath it, where nothing else would grow because the light could not get through. There were the Braddock family lots at the edge of the town cemetery, where the graves went back to the late 1700s, and where the earliest headstones were barely legible, the inscriptions worn smooth by more than a century of Virginia winters. Eleanor was the last surviving member of her generation. She was born in 1848, and had lived in the farmhouse at the edge of the orchard since her parents' deaths in the 1880s. Before that, she had lived in the same house from birth, had grown up in its rooms and on its grounds, had watched the orchard from the window of the room she had occupied since childhood. The orchard had been planted by her grandfather in the 1820s and consisted of apple trees, about 80 of them arranged in loose rows that had never been entirely regular because the ground was not entirely regular, the slope of it varying across the 12 acres in a way that the original planting had accommodated rather than fought against. In October, when the apples were ripe and the afternoon light came at its long autumn angle through the orchard, the trees gave off a smell that was sharp and sweet simultaneously, the smell of fruit at the precise moment between ripeness and fermentation, which was the smell that Eleanor had always associated with home. She had never married. She had received, in her 20s, several offers of the kind that young women of good Virginia family received in those years, and she had declined them with the politeness that was expected and the firmness that was, in her case, genuine. She was not opposed to marriage in principle. She was simply, as she had recognized in herself at an early age, a person who preferred the company of her own thoughts to most other available company, and who found the management of her own affairs both sufficient and satisfying, in a way that seemed to her incompatible with the adjustments that marriage would require. Her parents had not pressed her after the first few years. Her brother Thomas, who was 4 years older and who had married and established himself in Charlottesville, had occasionally expressed mild concern, but his concern was of the kind that family members express on behalf of a relative they have decided is making a choice they don't entirely understand rather than one that is causing actual damage, and he had not pushed. The orchard was managed by a tenant farmer named Josiah Wren, who had worked the Braddock land since Eleanor's father's time, and who continued to work it under the arrangement that Eleanor had maintained unchanged since her father's death. A specific share of the annual apple harvest, a small monthly payment for the maintenance work on the trees, and the use of the storage building at the far end of the orchard for his equipment. Josiah was in his 70s by 1912, reliable and somewhat slow, which was the appropriate pace for the orchard's requirements. The apple trees did not require urgency. They required consistency, the right pruning at the right time, the right attention to the conditions that produced good fruit, the recognition of what was wrong early enough to address it. Josiah had this kind of attention. Eleanor respected it and matched it with her own. She had kept a diary since she was 17 years old, when her mother had given her a cloth-bound book for Christmas, and she had begun using it the same day. 47 volumes later, the diaries occupied a full shelf in the bedroom bookcase, arranged by year, their spines visible from the bed in the morning light. The entries were practical rather than emotional in their primary register. What she had done, who had come, what decisions she'd made and on what grounds, what the weather had been, what the orchard had looked like in whatever season was current. She also wrote in every entry something she had noticed, not an observation she had looked for, but one that had arrived without prompting, the kind of thing that the day produced if you were paying attention. A bird she'd not seen before in the south pasture, the particular quality of the light on the creek on a September afternoon. The way the old Braddock oak looked against the sky in January, when all its leaves were gone and the structure of it was visible, the main trunk dividing and dividing again into branches that reached in every direction, with an economy that was also an extravagance, a tree that had been spending itself for over a century and had not yet run out. Lawrence Braddock was Thomas's son, and he was in his early 40s in 1912 when the quitclaim deed was filed. He was a businessman in Charlottesville of moderate success, managing properties and rental income with the steady competence of someone who has found his appropriate level and stayed there. He was not an unkind man. He was attentive to Eleanor in the way that nephews who expect to inherit tend to be attentive, consistently present enough to maintain the relationship, not so present that the attention seemed calculated. He came to the farmhouse several times a year, usually in the spring and in the autumn, and he brought fruit from his own garden and inquired about the orchard and the apple harvest and Eleanor's health, and he stayed for tea and then he left, and Eleanor filed these visits in the diary in the way she filed everything: date, duration, subject of conversation, her own reaction. He had first raised the subject of what Eleanor intended to do with the property in 1910, in the autumn, when she was 62, and the conversation had the quality of a question that had been being thought about for some time before it was asked. Eleanor had told him that she intended to continue living in the farmhouse for as long as she was able to, and that her will, which was a private matter, was in order with Miss Violet Carey, her attorney in the county seat. Lawrence had said he understood completely, and he had not pressed the question, and he had stayed for tea and talked about other things and then left. But he had continued to come in the spring and the autumn, and his questions about the orchard and the water rights and the county's development plans in the creek bottom area had become more specific over those 2 years, which Eleanor had noticed and filed in the diary without explicit comment. Miss Violet Carey had established her practice in the county seat in 1905, the year that Virginia admitted women to the state bar. She was the only woman attorney in the county, which meant that her clientele was largely women who preferred a woman attorney on grounds that ranged from the principled to the practical, and also men who had been recommended to her by women, and who found, when they consulted her, that her reputation was not merely political. Eleanor had engaged her in 1908 to review and update her will, which had been drawn by an elderly male attorney who had since retired, and whose drafting style had been, in Miss Carey's assessment, somewhat less precise than the current state of property law recommended. Miss Carey had redrawn it in cleaner language and had filed it with the county court, and had given Eleanor a certified copy, which Eleanor kept in the middle drawer of the desk in the front room. Eleanor became ill in the first week of March 1912. It was a year of influenza in that part of Virginia, a season when the illness moved through communities with the particular thoroughness of something that has found good conditions and intends to stay. Eleanor came down on the 6th of March with a fever that progressed rapidly over the following 2 days to the severity her doctor, Dr. Willoughby, described in his casebook as acute influenza with secondary chest involvement. Dr. Willoughby came on the 8th, on the 10th, on the 12th, and on the 14th. His entries for those days were brief and professional: fever temperatures, respiration rate, medication prescribed, general assessment. The 14th of March read: Miss Braddock, fever reduced slightly, still significant. Chest congestion persistent. Patient confined to bed and strongly advised against exertion. Will return on the 16th. Prudence, Eleanor's housekeeper of 8 years, managed the household through the illness. She was a capable woman in her 50s who had come to the farmhouse after the death of her own employer and who had stayed because Eleanor's household suited her temperament. Quiet, orderly, with regular hours and clear expectations. She managed the sick room with the same steady attention she gave the kitchen. The medications at their correct times, the broth brought up when Eleanor could manage it, the fire maintained at the temperature the doctor had specified, the room aired in the brief warmer part of the midday. She also kept her own household notes, which she had always done, the provisions, the accounts, the maintenance work done and by whom, and these notes recorded the pattern of the illness weeks with the same factual completeness she applied to everything else. Lawrence came to the farmhouse once during Eleanor's illness on the 7th of March, the day after she had first fallen ill. Prudence had met him at the door and told him Eleanor was unwell and confined to her room. Lawrence had expressed appropriate concern, had been invited to wait in the parlour, had drunk the cup of tea Prudence brought him, and had left after about 20 minutes without having been admitted to see Eleanor. Prudence's household notes for that day read, "Mr. Lawrence called. Not able to see Miss Eleanor. Tea in parlour. Left around 3:30. The notation was simple, as all her notations were simple. There was no way to make it say more than it said, which was that Lawrence had come on the 7th, had not seen Eleanor and had left. The quitclaim deed, bearing Eleanor's signature and the date of the 14th of March, was filed in the county records in November of 1912. Eleanor did not know about this for nearly a year. She recovered from her illness in late March, was back on her feet by April, and by May was walking the orchard boundary again, checking the winter damage and discussing the spring bloom with Josiah Wren. She resumed her diary. She received Lawrence's spring visit and noted it. She made no connection between his visit and anything else because there was nothing, at that point, to connect. In October of 1913, Miss Carey received from the county recorder's office a routine notice regarding a change in the deed record for the Braddock Orchard property. She read it, understood what it meant, and went to the farmhouse in person, which was not her usual manner of delivering information to clients, but which seemed, in this case, appropriate. She sat with Eleanor in the front room, with the October sun coming through the south window onto the desk where the certified copy of Eleanor's will sat in the middle drawer, and she laid the notice on the table between them and explained what it said. Eleanor looked at it for a long time, then she looked at the date on the deed. Then she said, in a tone that was steady with the particular steadiness of someone who is very angry and is not going to show it, "I was in bed, I had influenza, Dr. Willoughby was there on the 14th. "Yes," said Miss Carey, "tell me about your diary." The volume for 1912 was on the bedroom shelf, 5th from the left in that year's position. Eleanor removed it and brought it to the parlour. She opened it to the March entries. The diary entry for the 14th of March read, "Still in bed. The fever is less today, but Dr. Willoughby says another week at least. I have not been downstairs since the 9th. Prudence brought broth this morning and managed everything as she always does. The light through the window in the afternoon was unexpectedly beautiful, coming at an angle that seemed very spring-like despite everything. I watched the bare top branches of the apple tree by the south wall and thought about how much the orchard recovers in a single season after a hard winter, and how much that is like a good deal else. There was no mention of any visitor. There was no mention of any document. There was no mention of leaving the room." Miss Carey asked to review the diary entries for the entire illness period, which ran from the 6th to the 20th of March. Eleanor laid the diary open on the table. Miss Carey read each entry in sequence, making notes. Every entry confirmed the same picture. Eleanor confined to bed, Prudence managing the household, Dr. Willoughby coming on his regular schedule, no visitors, no documents, no departures from the sick room. The diary for Lawrence's single visit was on the 7th. A brief notation that he had called, that she had been unable to receive him, that Prudence had reported he had stayed for tea and left. Nothing on the 14th or on any surrounding date that suggested any transaction of any kind had taken place. Miss Carey said she would need Prudence's household notes and Dr. Willoughby's casebook entries. Both were straightforward to obtain. Prudence's notes for March 1912 confirmed the dates of the doctor's visits and the absence of any other visitors after the 7th. Dr. Willoughby had his casebook and had no objection to providing a certified extract of the relevant entries. He was, in fact, somewhat indignant about the situation, which indicated to Miss Carey that he had formed his own clear view of what had occurred. She also engaged a professor at the university in Charlottesville who specialised in document examination. He reviewed the signature on the quitclaim against a collection of Eleanor's signed letters and documents covering a span of 10 years. His written opinion, delivered in December of 1913, was that the signature on the quitclaim differed from Eleanor Braddock's established signature in several specific particulars. The characteristic slope of the capital E, the formation of the terminal letters in her surname, the relative proportions of the upper and lower loops in the final K. The differences were not gross, he noted. They were the differences that distinguish a competent reproduction from an original, the kind of differences that a county recorder reviewing routine filings would not necessarily notice. But they were, in his professional opinion, consistent with an attempt to replicate a signature from a source copy rather than a direct original. The Circuit Court convened a hearing in February of 1914. The proceedings were quiet, which was appropriate. Courts hearing evidence of forgery in Virginia in 1914 did not generally conduct themselves with theatricality, and neither Miss Carey nor Eleanor Braddock had any interest in theatre. Miss Carey presented the diary, the household notes, the doctor's casebook extracts, and the handwriting professor's opinion. Lawrence Braddock was present with his attorney. Lawrence's attorney made a brief argument that the evidence was circumstantial. Miss Carey responded that the word circumstantial was being used to describe a converging set of independent contemporaneous records, all of which supported the same conclusion. The judge reviewed the materials over 2 days and issued his written opinion on the 5th of February. The quitclaim deed was declared void. The Braddock Orchard property remained in Eleanor Braddock's name. Lawrence was not prosecuted. Eleanor had declined to pursue that avenue. She had explained this to Miss Carey in the simplest possible terms. She was 66 years old, she wanted the orchard, she did not want a lawsuit, and she had observed in her life that the people who pursue justice beyond the point where justice has already been achieved generally find that the additional pursuit costs them more than it gains them. Miss Carey had not argued. She had filed the court's ruling with the county recorder and sent Eleanor a copy, which went in the middle drawer of the front room desk beside the certified copy of her will. Eleanor Braddock lived until 1927. She managed the orchard through Josiah Wren until his death in 1921, then through Josiah's son, who had learned the trees from his father and managed them with the same steady competence. She continued to walk the orchard boundary in the seasons when the ground permitted it, continued to watch the October harvest and smell the particular sharpness of ripe apples in the afternoon sun, continued to write in the diary every morning and every evening. She noted the court's ruling in her diary on the day she received the copy from Miss Carey's office. The entry read, "The orchard is mine, as it has always been. The records were clear, as they have always been." I'm glad of this, though not surprised by it. A diary is a very simple thing when you think about it. A record of what actually happened, in the order in which it happened. It should not be remarkable. But I have found, over 47 years, that what is simple and what is remarkable are often the same thing. She left the orchard and farmhouse to the County Historical Society in her will of 1920, updated and confirmed in 1925. The provision she added in her own handwriting at the end of the bequest read, "I leave the orchard in the confidence that it will be properly cared for. The deed has always been mine. The records have always been clear. I ask only that the trees be looked after, and that whoever manages this property keep good accounts. Good accounts are what everything else depends on. I have known this for 47 years. The orchard is still there. The apple trees have been replanted twice since Eleanor's time, but the arrangement follows the original pattern, the loose rows accommodating the irregular slope of the ground, the way her grandfather had planted them in the 1820s. In October, when the apples are ripe, the orchard produces the same smell it has always produced. Sharp and sweet and slightly fermented. The smell of abundance at its moment of completeness. The creek along the south boundary still runs reliably through drought years. The ridge still shelters the valley from the northeast wind. The diary is in the County Historical Society's archive, all 47 volumes of it, in a temperature-controlled cabinet with the other Braddock family papers. The volumes for 1912 and 1913 have been accessed over the years by researchers studying the history of women's property rights in Virginia. The entry for the 14th of March 1912 has been cited in 3 academic papers. The entry for the 5th of February 1914, noting the court's ruling, has been cited in 1. The entry about the particular quality of the afternoon light through the window on the 14th of March, the bare branches of the apple tree against a spring-like sky despite the illness and the season, has not been cited in any academic paper. It belongs to a different kind of record. The orchard in February looked nothing like the orchard in October, and this was one of the things Eleanor Braddock found most instructive about it. In October, with the apples ripe and the leaves still mostly on the trees, and the afternoon sun working through the canopy to make particular patterns on the ground beneath, the orchard was abundantly itself, demanding attention, offering its fruit and its smell and its colour. In February, bare and skeletal against a Virginia sky that was grey more often than not. The orchard was reduced to its structure. The line of each trunk, the branching architecture of each tree, the specific manner in which each had grown toward light over the decades of its life. She had been looking at these trees for 65 years, and she knew each one individually. the way you know things you've been attentive to for very long periods, not as types, but as individuals. Miss Violet Carey had come to the county bar in the year that Virginia admitted women, 1905, and had established her practice in the county seat before most of her potential clients had fully accepted that women could be attorneys. She had accepted this as a temporary problem. The clients she gathered in the first years were largely women who shared her conviction that a woman attorney was a practical good, not merely a symbolic one, and she managed their affairs with a thoroughness that produced referrals, and the referrals produced a practice, and the practice after 8 years was established enough that she no longer needed to explain herself to people who had not yet decided whether to trust her. She had reviewed the quitclaim deed on the same evening she had received it from the county recorder's office. She had read the document carefully and completely, the way she read all documents, starting with the parties and the date, moving through the consideration and the property description, arriving at the signature and the notarization. The signature was Eleanor Braddock's name. The date was the 14th of March, 1912. The notarization bore the stamp and signature of a notary in Charlottesville whose name she recognized as legitimate. None of this was, by itself, impossible. People signed documents under a range of circumstances, and sometimes those circumstances were complicated. What was, in her assessment, highly improbable was that Eleanor Braddock had been well enough in mid-March of 1912 to travel to Charlottesville to sign a document, or that a notary had come to her while she was reportedly unwell, without any record of such a visit in her household accounts or her diary. The handwriting expert, Professor Clement Aldrich of the University in Charlottesville, had examined questioned documents for 20 years. His field was not glamorous, and it was not widely understood, and it had the particular disadvantage of being applicable in precisely those situations where people preferred not to believe that documents could be false: estates, contracts, letters of instruction. He had learned to present his findings with the restraint that evidence requires and the clarity that courts require, which were not always the same thing. His opinion on the Eleanor Braddock quitclaim was not the most complicated he had ever produced, but it was one of the clearest. The signature differed from the established signatures in its terminal letter forms, in the angle of the capitals, and in the pressure pattern, which forensic analysis could detect and which was consistent with a model copied from a two-dimensional reproduction rather than produced naturally by the signer. Prudence had worked for Eleanor for 8 years by the time of the illness, and she had the particular competence of someone who manages a complex household with minimal direction. She knew what needed doing and she did it, and she recorded what she did in the household notes with the same concise thoroughness she applied to the doing. The notes were not intended to be evidentiary documents. They were working notes, the memory of the household written down so that it didn't need to be held in a person's head. They had the authority that working documents have when the work they describe is accurate and honest and completely routine. They were clearly not prepared for any particular purpose, which meant they had no obvious bias, which made them exactly the kind of evidence that courts find useful. Eleanor had not, in the years of dealing with Lawrence's visits and questions, been entirely certain what he intended. She had been certain, from early on, that his interest in the property went beyond family feeling. She had not been certain whether his intentions would eventually produce a deceptive act, or whether she would simply need to be clear about her will and its provisions and trust that the legal record would be sufficient. She had, partly for this reason, kept her diary with somewhat more attention to specificity than she might otherwise have, noting the dates and durations and subjects of Lawrence's visits, the questions he asked, her own responses, the condition of the orchard discussed. Not because she was building a record against him, because she was a woman who kept careful records, and keeping them carefully meant keeping them in detail. The Braddock Family Land Trust, as Lawrence had described it to the county recorder's office when filing the quitclaim deed, was a structure he had established in 1911 with the intention of consolidating the family's remaining property interests under professional management. This was not in itself an improper aim. The trust was a legitimate legal entity, properly established, with a trustee appointed and a trust agreement on file. Its problem was not that it was illegitimate, but that it had been expanded by the quitclaim deed to include property that had never been offered for inclusion. Eleanor had not been asked. She had not agreed. She had not signed a document agreeing to this arrangement. The document claiming her signature was a fabrication, which the court had determined. After the hearing, after the court's ruling had been filed, and the certified copy had been sent to Miss Carey, and Miss Carey had sent a copy to Eleanor. Eleanor had written to Lawrence a single letter. It was brief, because she had decided to say only what needed to be said and nothing additional. She told him that she had received the court's ruling. She told him that the property remained hers and would be handled according to her will, which he was not a party to and about which she was not going to tell him anything. She told him that she hoped this was the end of the matter between them, because she was 66 years old, and she had better things to do with her time than to spend it in dispute with her nephew. She signed it Eleanor Braddock, and sealed it, and sent it by registered mail, which produced a receipt that she filed in the middle drawer of the front room desk. The apple harvest of 1914 was a good one. Abundant, well-timed, the summer having been warm and reasonably wet in the proportions that apple trees favour. Josiah Wren worked the harvest through October, with the deliberate thoroughness of a man who's been harvesting the same trees for 30 years and knows exactly when each variety is ready. Eleanor walked the orchard during the harvest in the afternoons, after the heat of the day had passed, moving between the rows with the ease of familiarity. The apples that had fallen on their own were already fermenting in the grass beneath the trees, producing the sharp, sweet smell that was the orchard's October identity. She ate one from the tree, a winesap, which was her favourite. It was exactly right. She continued her diary through the years after the 1914 hearing without any change in her manner of keeping it. Date, weather, what she had done and who she had spoken to, something she had noticed. The entries about the court hearing and its outcome were as factual and as brief as any other entries in the diary. She noted that the hearing had taken place, that the ruling had been issued in her favour, that the quitclaim had been declared void, that she had received Miss Carey's copy of the ruling. The entry for the day after she received the ruling noted that it was a clear, cold February morning, that Josiah Wren had come by to check on the storage building, and that the Admiral, which was the large old apple tree at the far end of the orchard that she had named privately, after the original tree planted by her grandfather, appeared to have suffered some frost damage on its southernmost branches. She had examined it carefully and concluded that the damage was superficial and that the tree would recover in the spring, which it did. Albemarle County in 1927, the year of Eleanor's death, was in the process of change that American rural counties were undergoing throughout the decade. The automobile was making distances more fluid, the county road was being improved, new houses were appearing in what had been farmland at the edges of the county seat. Eleanor had watched these changes with the attentiveness of a woman who has lived long enough to watch several rounds of change, and who has learned to distinguish between the changes that alter what a place fundamentally is and the changes that merely alter its surface. The orchard was the same orchard it had always been. The creek ran along the same south boundary. The trees that Josiah's son had planted to replace the ones that had died were in their second decade of bearing and were producing well. The place was a place. Its essential nature was not mobile. Miss Carey prepared Eleanor's final will in 1925, reviewing and confirming what had been established in 1920. She noted in her client file that Eleanor had been, over the years of their professional relationship, one of the clients she found most satisfying to work with. Clear about what she wanted, patient about the process of achieving it, and possessed of that particular quality of preparation that made every meeting efficient because the client had already thought through what needed thinking through before she arrived. She noted also that Eleanor kept excellent records, which was an understatement, and that she maintained her property in a condition that reflected her character, which was another way of saying that the orchard was well managed and the farmhouse was maintained and the south boundary was where it had always been and the water rights were intact. The County Historical Society, when it received Eleanor's bequest, found that managing an orchard was more complicated than it had expected. This was also not unusual. Charitable institutions that receive productive property are frequently surprised by the ongoing demands of the property itself. They hired Josiah Wren's son to continue managing the apple trees, which he did for 12 years before his own retirement, and then they hired the next appropriate person, and the orchard continued to be an orchard, which was what Eleanor had asked for. The diary volumes are in the Historical Society's archive alongside the other Braddock family papers. The 47 volumes occupy a full shelf in the temperature-controlled section, each volume in its acid-free enclosure, each labelled with its year and cross-referenced with the family's other records. Researchers visit occasionally. The 1912 volume is one of the more frequently requested, because the entries for March of that year, the daily record of an illness, the absence of visitors, the light through the window on the 14th, have become a small example in the literature about historical document authentication of the kind of private record that resists specific forms of fraud. The Admiral is mentioned in the 1914 volume, in the entry about the October harvest. She ate one from the tree, a wine sap, and it was exactly right. The handwriting expert's report, when Miss Carey read it for the first time, produced in her a feeling she had learned to recognise as professional satisfaction of a particular kind. Not the satisfaction of an argument made, but the satisfaction of a fact established. An argument could be disputed. A fact established by independent expert analysis, documented in a written report with specific and verifiable observations, was a different order of thing. The differences Professor Aldrich described, the slope of the capital E, the terminal formation of the surname, the pressure pattern inconsistent with natural signing, were small differences, as he noted. They were exactly the small differences you would expect to find in a competent reproduction, small enough to pass a casual inspection, detectable on systematic examination by someone who knew what to look for. He was someone who knew what to look for. He had been looking for this kind of thing for 20 years. The circuit court in Albemarle County was housed in a building of red brick that had been the county courthouse since 1860, replacing a wooden structure that had burned in a fire whose cause was, depending on who you asked, careless maintenance or the war. The replacement had been built solidly, as post-war courthouses in Virginia tended to be built, with an attention to permanence that was partly practical and partly expressive of something about how the county wanted to be seen after the disruptions of the preceding decade. Eleanor Braddock had appeared before the circuit court once before in her life, in a property matter in her father's time, and she remembered the building as one that took itself seriously, which was, she thought, appropriate for a building where things that needed to be decided were decided. Miss Carey had prepared for the February 1914 hearing with the particular thoroughness of an attorney who understands that the strength of her evidence does not make preparation optional. She had organised the diary entries by date and cross-referenced them against the doctor's casebook extracts and Prudence's household notes, producing a chronological table that made the pattern clear at a glance. Eleanor confined to her room from the 9th to the 20th, Dr. Willoughby visiting on the 8th, 10th, 12th and 14th, Prudence in the household records for each of those dates, no visitors noted after Lawrence's unsuccessful call on the 7th. The table was a distillation of 4 independent contemporaneous records, all confirming the same facts about the same period. She had it printed clearly and brought 3 copies to the hearing, one for the judge, one for Lawrence's attorney, and one for her own reference. Eleanor had worn, to the hearing, the dark wool dress she wore for formal occasions, which she had owned since 1908, and which fitted her well, and which she associated with occasions that required her to be publicly herself rather than domestically herself, which was a distinction she maintained without difficulty. She sat beside Miss Carey at the plaintiff's table and listened to the proceedings with the attentiveness of a woman who has been keeping careful records for 47 years and who therefore understands precisely how records work and what they establish. She was not nervous. She had the documents. The documents said what they said. The court would read them and decide accordingly, and the decision would be correct. The orchard in the spring after the hearing bloomed as it always bloomed, indifferent to the legal proceedings that had recently confirmed its ownership. The apple trees did not know who held the deed. They flowered because the temperature had reached the threshold that triggers flowering, and they would fruit because the pollination conditions were met, and the fruit would ripen because the summer sun accumulated above the threshold that ripening requires. Eleanor walked among the trees in April when the bloom was at its fullest, the white and pale pink flowers that covered each tree from a distance, making the orchard look, as she had always thought, slightly improbable, as though someone had arranged it for a painting rather than for a harvest. She ate a blossom from one of the winesap trees, which she had always done when the bloom was at its peak, because the blossom tasted of the apple that would eventually come from the same wood, and because she found it useful to be reminded in April of October. The diary had been Eleanor's most reliable companion through 65 years of life in Albemarle County. It had been her companion through the deaths of both parents, through 2 significant droughts that had threatened the orchard, through the illness of 1912 and through the legal proceedings that followed. She did not use it for comfort in the way that some diaries are used, as a place to put the feelings that have nowhere else to go. She used it as a record, and the record included feelings only when feelings were themselves facts about a day. She'd been anxious about the orchard in the drought year of 1895, and she'd written this down, because the anxiety was relevant to her understanding of that year. She had been, when Miss Carey brought the notice from the county recorder's office, very angry, and she had written this down. She had been, when the court's ruling arrived, relieved and not surprised, and she'd written this down. She wrote it as she wrote everything, factually, precisely, without embellishment. Lawrence had continued to visit after the court's ruling, which surprised Miss Carey and did not surprise Eleanor. He came in the spring of 1914, and he came in the autumn of 1914, and his visits had the quality of visits made by a person who has decided that continuing as if nothing has happened is the most viable available option. Eleanor received him with the same courtesy she had always shown, offered the same tea, asked about his business, and did not mention the court proceedings or the quitclaim or the ruling. Neither did he. This was, she had decided, the appropriate resolution. Not warmth, not hostility, but the specific form of continued relationship that requires the most difficult thing, the maintenance of ordinary civility and the knowledge of what has occurred. She did not expect it to feel comfortable. She expected it to be correct. It was both. The historical context of the Braddock case is a specific chapter in the larger history of forged documents in American property law. Forgery of signatures on property documents was not uncommon in the Gilded Age, particularly in transactions involving elderly landowners, and the county recorders of the period were, by modern standards, limited in their ability to detect forgery at the point of filing. They confirmed that the document was properly formatted and appropriately notarized, not that the signatures were genuine. The vulnerability was structural. What protected against it was exactly what protected Eleanor Braddock, a contemporaneous record of where she actually was and what she was actually doing on the date in question, maintained by multiple independent sources: her own diary, her housekeeper's accounts, her doctor's casebook, none of which had any reason to agree with each other except that they were all accurately recording the same facts. The orchard will bloom again in April. It always does. The trees that Eleanor's grandfather planted in the 1820s are long gone, and the trees that her generation tended are gone, and the trees planted after her death have now been replaced in their turn, but the orchard is still an orchard, the same 12 acres, the same irregular slope accommodated by the same loose rows, the same south-facing orientation that catches the afternoon light in October and makes the ripe fruit glow. The County Historical Society tends it with the care that Eleanor requested. Good accounts kept, the trees looked after, and in October, when the harvest comes in and the smell of ripe apples fills the south slope of Albemarle County, it is the same smell it has always been. Sharp and sweet and slightly fermented. The smell of abundance at the moment of its completion. The smell of what has been carefully tended and has produced what it was tended to produce. By 1928, the Cartwright Trust had been in existence for 44 years. In that time, it had survived a financial panic, a world war, the deaths of both the man who had established it and the attorney who had drawn it up, and 2 complete transitions of trusteeship from one generation to the next. It had been administered by 3 successive generations of Cartwright women, first by the founder's wife Carolyn, then by the founder's daughter Elizabeth, then by Elizabeth's daughters Miriam and Ruth, with a consistency and a care that the original trust document had required, but that no one outside the immediate family had entirely believed possible over so long a period. The Nephews, who arrived in the autumn of 1928 with a petition to the county court challenging the trust's management, had spent several months preparing what they believed was a thorough case. They had reviewed the distributions, they had consulted financial advisors, they had prepared market comparisons. They had not, because it had not occurred to them to do so, reviewed the filing cabinets. Elias Cartwright had established the trust in 1884 in the 59th year of his life and the 35th year of his marriage to Caroline Whitmore Cartwright, whom he had married at 24 and who had, in those 35 years, demonstrated to him in daily practice what he had suspected when he married her, that she had a better head for money than he did. This was not, in 1884, a common observation for a man to make about his wife, even privately. It was the kind of observation that required a certain kind of man, one who paid attention to evidence over long periods of time, who revised his positions when the evidence warranted revision, and who found it more important to be accurate than to be conventionally correct. Elias Cartwright was a manufacturer of textile machinery from New Haven, Connecticut, and the precision his business required, the tolerances of the machinery, the specifications of the parts, the exact timing of production schedules, had given him a habit of exactness that extended into his domestic observations as well. What he had observed over 35 years was this: Caroline managed the household finances with a discipline and a long-term view that he found remarkable. She maintained accounts that were accurate to the penny. She made decisions about household expenditure that reflected an understanding of the relationship between short-term cost and long-term value that his own business partners did not always demonstrate. She had, when he had consulted her, in the early years of their marriage, cautiously, not wanting to make her self-conscious, offered opinions on business decisions that had proven, on review, to be more consistently accurate than the opinions of most of his professional advisors. He had stopped being cautious about this somewhere in the middle years of their marriage and had begun consulting her routinely, which she managed with a discretion that he recognized was as much for his protection as for hers. She never claimed credit for the decisions he arrived at through conversations that began with her observations. Their daughter Elizabeth was born in 1860 and had, by the time Elias began thinking seriously about the trust, already demonstrated that she had inherited her mother's aptitude. She was 24 in 1884, unmarried, and working alongside Caroline in the management of the household finances with the same thoroughness and the same long-term view. She had absorbed accounting from her mother the way some children absorb music or language, not through formal instruction but through proximity and repeated practice, through the accumulated experience of watching something done well for long enough that the doing of it became natural. Elias had written a letter to his solicitor, Mr. Andrew Horne, in the spring of 1884, explaining his intentions. The letter was long and direct. He said that he had observed, over many years, that the women of his family managed money more carefully than the men. He noted that his wife had administered the household accounts for 30 years without error. He noted that Elizabeth was demonstrating the same aptitude. He acknowledged that he was uncertain about the specific individuals among his male descendants who might prove capable stewards, but that he had no time left to wait and determine this through experience. He said that the trust he intended to establish would place its management with the female line not because he believed the male members of his family were incapable in principle, but because the evidence available to him supported the female line's capability specifically and clearly, and the evidence for the male line was insufficient. He was, in short, making a decision based on what he knew, rather than on what convention suggested he ought to assume. The trust document that Horne drew up was precise in proportion to the clarity of Elias's instructions. It established a trust for the benefit of the Cartwright family in perpetuity for 3 generations, distributing income to the male members in specified proportions. It placed control of the principal and all investment decisions with the female line, initially with Caroline, then with Elizabeth, then with Elizabeth's female descendants. It specified that the trust would continue for 3 generations after Elias's death, at which point the principal would be distributed as the final female trustee saw fit. It did not restrict what the female trustees could do with the principal's investments. It specified only that the trustees act in the interest of the trust's beneficiaries as a whole, which was the standard fiduciary language of the period, and which Horne had included because it was correct, and because he thought Elias's daughters and granddaughters would find it a sufficiently clear mandate. Caroline Cartwright took up the trusteeship in 1885, the year after Elias's death, and she administered it for 22 years. She was 60 at the time she became trustee, which was not considered young, and the trustees of other family trusts in Connecticut tended to be men who held such positions in their 40s and 50s. But Caroline had been effectively managing the trust's forerunner, the household finances that had grown, over Elias's prosperous years, into something considerably more complex than most households managed, for 30 years, and the transition from informal to formal management was less a change of kind than a change of documentation. She began keeping formal trust accounts from the first day, in the format that she and Horne established together: quarterly reports of income and expenditure, annual summaries of investment decisions and their rationale, correspondence files for every significant communication. She was, by her own account in a letter to Elizabeth in 1886, enjoying the formality, because formality left a clear record of what had been done and why, and she had always found clear records more comfortable than uncertainty. The panic of 1893 was Caroline's first major test. She had been watching the market nervously through the spring and early summer, and in June she had sold the Trust's most volatile holdings, a set of railroad bonds that had performed well through the 1880s, but that she had been following with increasing concern through the first months of 1893, and reinvested the proceeds in the more conservative instruments that had been the Trust's original core, government bonds and steady-yielding real estate. The panic arrived in late summer, and the railroad bonds collapsed. The investments she had sold held. The Trust's capital at the end of 1893 was essentially what it had been at the beginning, which was not something that most private trusts in Connecticut could say about that year. Elizabeth managed the Trust from Caroline's death in 1907 until her own in 1921. She had attended every significant meeting between Caroline and the Trust's solicitors from the age of 20 onwards, at Caroline's insistence, and she had maintained a parallel set of notes on every such meeting since her early 20s. Not the official minutes, which Horne's office maintained, but her own notes on what had been discussed, what had been decided, and what she had thought about each decision at the time. These notes were in their own folder in the Trust's filing cabinet, in Elizabeth's hand, from 1882 onwards, a continuous running record of her engagement with the Trust's affairs over 4 decades, beginning 6 years before she officially became involved in its management. When she became the primary trustee in 1907, she had been effectively studying and practicing for the role for 25 years. The panic of 1907 arrived in October, and Elizabeth had been watching for it since the spring. She had read the financial press with attention, and had concluded, sometime in August, that the credit expansion of the previous 3 years was not sustainable. She had sold the Trust's equity holdings in September, converting the proceeds to cash and to short-term government bonds. The panic, when it arrived, was sharp and brief, but its effects on equity markets were severe. The Trust's capital at the end of 1907 was higher than at the beginning, because the cash and bonds held their value while equity fell. This outcome was documented in the annual report Elizabeth prepared in January of 1908, 23 pages, covering every investment decision and its rationale, the market conditions that had informed each, and the outcome. She had been writing annual reports since 1897, when she decided that annual reports were both professionally appropriate and personally useful, and she had written them with increasing specificity each year. Miriam Marsh, who had her mother's name and her grandmother's accounts, having kept shadow ledgers of the Trust's affairs since her mid-20s, became co-trustee with her sister Ruth in 1921 following Elizabeth's death. Ruth was 4 years younger than Miriam, 41 to Miriam's 45, and had spent the years of their mother's trusteeship managing the distributions to the Trust's beneficiaries and tracking their impact, which members of the extended family received what, whether the distribution amounts were adequate to their needs, whether any adjustments were warranted. She had done this not because it was formally required of her, but because she thought someone should be doing it, and she was in the best position to do it, and the kind of thinking that monitors ongoing distributions against ongoing needs had always been natural to her. They established their shared office in the Pratt Street building in Hartford in 1924 when Ruth moved to the city. The office was on the 4th floor with windows facing south, and the light that came through the south windows in the afternoons had the quality of light that falls through windows in rooms where serious work is done. Not dramatic, not particularly beautiful in itself, simply present. The light of an ordinary autumn afternoon in a New England city in a room that has been used steadily for a long time. The filing cabinets stood along the east wall, 4 of them, full height, their drawers labelled by year and category. The earliest drawers contained documents from Caroline's trusteeship, in her handwriting, and in Horne's and in Elias's. The most recent drawers contained Miriam and Ruth's work, the annual reports, the correspondence, the investment records, the distribution ledgers. The nephews of the 3rd generation were men in their 30s and 40s who had grown up knowing that there was a Cartwright trust that paid quarterly distributions and that was managed by the women of the family. They had received these distributions their entire adult lives, as their fathers had before them, and their grandfathers before that. The trust had always been there. The distributions had always arrived. They had not, until the late 1920s, thought much about how the trust was managed or whether it was managed well. The late 1920s changed this. The change was partly economic and partly temperamental. The economic context was the extraordinary performance of equity markets through the mid and late 1920s, which produced returns so consistently high that conservative management looked, in comparison, like a failure of ambition. Percival Cartwright, the eldest of the third generation at 42, had a financial advisor in New York who was enthusiastic about the potential returns available in Florida real estate and in the industrials that were driving the market to record heights. Percival's view was that the Cartwright Trust, under Miriam and Ruth's conservative management, was significantly underperforming what it might do if its assets were more aggressively deployed. He had put this view in writing to Miriam in the spring of 1928, in a letter that cited market comparisons and projected returns, and expressed, with the courtesy of a man who considers himself to be raising a legitimate concern, that perhaps it was time for professional investment management to supplement what the trustees were able to provide. Two cousins agreed with him. Frederick wanted the trust to invest in a new manufacturing concern his father-in-law was establishing. Clement had more general complaints about women managing a substantial family asset without adequate oversight. Together, they consulted an attorney and filed a petition with the county court in September of 1928, asking the court to review the trust's management and to consider appointing a professional co-trustee. Miriam and Ruth received the petition on a Tuesday morning in October. They read it together at the Pratt Street office, with the autumn light coming through the south windows onto the filing cabinets and the desk where the current year's trust accounts sat in their folder. Then Miriam made a cup of tea. Then Ruth said, 44 years. Then Miriam said, we'd better show them. Neither of them was particularly alarmed. They had both, in different ways, anticipated something of this kind for some time, which was why the filing cabinets were as complete as they were. Their attorney, Miss Louise Fenwick, had been admitted to the Connecticut bar in 1924 and was regarded as capable in the way that attorneys are regarded as capable when they consistently win cases that looked complicated from the outside. She reviewed the filing cabinet contents over 3 weeks in October, the annual reports, the investment records, the distribution ledgers, the correspondence files. She calculated the trust's rate of return in each year of its existence. She compared the trust's performance against alternative strategies that might have been pursued in the same periods. She found that the trust had underperformed in the strongest years of equity markets and outperformed in every period of market difficulty. She calculated the net result across 44 years. The trust's capital had more than doubled in real terms, a result that she considered, in her written analysis, to be substantially better than the comparable private trusts she had reviewed in her practice. She also found the 1884 letter, Elias Cartwright's letter to Andrew Horne, explaining his rationale for placing the trust's management with the female line. It was in the correspondence file for 1884, in its original envelope with the note in Horne's filing hand on the outside. Miss Fenwick read it twice. She showed it to Miriam and Ruth. They had both known it existed because Caroline had told Elizabeth about it, and Elizabeth had told Miriam and Ruth, but none of them had specifically thought about it as a document that would be relevant to a legal proceeding, because they had not anticipated a legal proceeding until the petition arrived. It was relevant. It was very relevant. A founding document explaining in the founder's own words and at the moment of the trust creation why the management structure existed and what it was intended to accomplish. This was exactly the kind of primary source that courts found useful when interpreting a trust's terms. The market began to provide its own commentary in October of 1928. Florida real estate values, which Percival's financial advisor had been enthusiastic about, had already been declining for 2 years. The speculative bubble there had peaked in 1926 and had been deflating steadily since, though this was not yet widely understood outside the region. By the time the January 1929 court hearing approached, several of the specific investments that Percival had cited as examples of what the trust should have done were visibly performing poorly. The industrial equities that had been driving the market to record heights were showing signs of the kind of volatility that precedes a correction. The judge in the case had access to the same financial press as everyone else. The hearing was on a cold January morning. The filing cabinets could not come to court, but their contents could, and did. 44 years of trust records, condensed and organised by Miss Fenwick into a presentation that moved from Elias's founding letter, through Caroline's 22 years of management, through Elizabeth's 14 years, through Miriam and Ruth's 7 years to the present, with the performance analysis at the end. Percival's attorney presented the market comparisons and the Florida real estate projections, which looked somewhat less compelling in January of 1929 than they had in September of 1928. The judge reviewed the materials over 2 days. His written opinion noted that the trust had been administered with exemplary prudence over 44 years, that the performance compared favourably to professional trust management, and that the production by the trustees of 44 continuous years of documented records represented a standard of administrative transparency that ought to be more widely emulated. He dismissed the petition. He made no comment on the market comparisons, which was perhaps the most eloquent part of his opinion. The trust continued. Miriam continued as primary trustee until 1941. Ruth, who outlived her sister, continued until the trust's 3-generation period was complete in 1942, at which point she oversaw the distribution of the principal to the charitable interest that Caroline had originally intended: the college in New Haven that Elias had supported, the hospital in Hartford, the school in the Cartwright family's original Connecticut town. The amounts were larger than anyone outside the family had expected. 44 years of careful management had produced results that careful management tends to produce. In October of 1929, 9 months after the court dismissed the petition, the stock market collapsed. The investments that Percival had favoured, the industrials, the leveraged positions, the real estate paper, lost most of their value in a matter of weeks. The Cartwright Trust, holding government bonds and conservative real estate, was essentially unaffected. Miriam noted this in the annual report for 1929 without particular comment, because the annual report was not the place for triumph and because she didn't feel triumphal. She felt, as she wrote in a letter to Ruth that December, primarily tired and right. Ruth Marsh died in 1949 at the age of 82. Her obituary in the Hartford Courant described the Cartwright Family Trust as a model of private philanthropic management, and noted her 6 decades of service to it. There was no mention of the 1928 petition. There was no need. The filing cabinets, which had been donated to the Connecticut Historical Society, along with the Trust's other records, held the complete story of what had happened. 44 years of documents that spoke for themselves in the orderly and legible manner of records kept by people who understood that records are what make things knowable across time. The Pratt Street office is something else now. The south-facing windows let in the same autumn light they always have, which is all that windows can do. Accept the light that comes and make it available to whoever is in the room. The filing cabinets are gone, distributed to the archive, but the light is there, and if you sit in the room where the cabinets were and close your eyes and let the afternoon in, you can understand what they held. Not just the documents, but the attention that created the documents, the daily discipline of a quarterly report prepared, a correspondence file maintained, an annual summary written and filed. Caroline's habit passed to Elizabeth, passed to Miriam and Ruth, passed now to the archive, which will hold it until someone needs to know what it says. The Connecticut River Valley in autumn is a landscape of particular restraint. The hills fold down toward the river in long curves. The light comes at a low angle that turns the remaining leaves from gold to copper to brown in a matter of days, and the river itself, wide and steady, and carrying the colour of the sky, moves with the indifferent patience of water that has been following this same course for 10,000 years. Hartford sits above the river on its modest rise, and the Pratt Street building where Miriam and Ruth maintained the trust office had a view, from the south-facing windows, of the river and the hills beyond it. The view changed season to season, as views do. The trust accounts, filed in their cabinets along the east wall, did not change, they accumulated. The accumulation of 44 years of trust records was not in itself remarkable. Careful institutions kept records. What was unusual about the Cartwright Trust records was the consistency of the methodology across 3 different trustees and 4 decades. Caroline's accounts were kept in one hand, in one format, from 1885 to 1907. Elizabeth had adopted the same format when she took over in 1907, using the same account categories, the same quarterly reporting structure, the same annual summary form. She had continued Caroline's innovation of attaching a letter of explanation to each annual summary, a practice Caroline had begun in 1887 after Horne had asked her to explain a particular investment decision, and which she had found useful enough to continue without being asked again. Miriam and Ruth had continued this practice from 1921. By 1928, the annual summary letters ran to an average of 18 pages each, which was longer than Caroline's had been but shorter than Elizabeth's, and they included investment rationale, market observations, and distribution analyses that reflected two people's thinking rather than one. Elias Cartwright's letter to Andrew Horne, the founding document that Miss Fenwick had found in the correspondence files for 1884, was written in the direct style of a man who expected to be taken seriously and did not spend language on ensuring this. He described his observations about his wife's financial management over 35 years. He described his daughter's developing capability. He noted specifically that he had made several business decisions in the 1870s and 1880s that had been influenced by conversations with Caroline, and that those decisions had, in retrospect, been among his better ones. He said he was making this provision not as a sentimental gesture but as a practical one, based on the available evidence. He said he was aware that his decision would not be universally admired, and that he found he did not particularly care about this, because he was 60 years old and he had learned that the admiration of conventional opinion was a thing that came and went without much relevance to the quality of decisions. Andrew Horne had been Elias's solicitor for 20 years before the trust was established, and he had known Caroline well enough to understand what Elias was describing. He had himself consulted Caroline about the trust instrument's drafting when certain aspects of it were proving difficult to phrase precisely, specifically the provisions about what the female trustees could and could not do with the principal, where the balance between flexibility and specificity was delicate. Caroline had clarified her own understanding of what she thought was needed, and Horne had translated this into the legal language that the trust instrument required. His copy of the letter Elias had written him was filed in his own professional records, and the copy that came to rest in the Cartwright Trust's filing cabinet was a certified copy that Horne had made at Caroline's request when she began the formal trusteeship. The certification confirmed the date and the authenticity. The date was January of 1884, 3 months before Elias's death, and 8 months before Caroline formally assumed the trusteeship. The filing cabinets themselves were objects of a specific era of office supply, full-height wooden cabinets with brass hardware and divided drawers, whose dividers were labelled in the hand of whoever had last reorganised them. Caroline had organised the first cabinet herself when she began the trusteeship, and her labels, quarterly reports, annual summaries, beneficiary correspondence, investment records, legal correspondence, were still legible on the original dividers, the ink somewhat faded but the lettering still precise. Elizabeth had added a second cabinet in 1898 when the first was full, and had adopted Caroline's labelling system without modification. Miriam had added the third and fourth cabinets in 1924 and 1926 respectively. The system was consistent across all 4 cabinets, across all 4 decades, which meant that Miss Fenwick, reviewing them in October and November of 1928, could move from 1885 to 1925 and back without losing her place. The beneficiaries, the male members of the Cartwright family who received quarterly distributions, had been for most of the trust's existence a presence in the records rather than in the office. Their names appeared in the distribution ledgers quarterly, their addresses updated when they moved, their signed receipts filed in the beneficiary correspondence drawers. Their requests for additional distributions above the specified amounts, when they occurred, had been handled by mail and had almost always been declined, because the trust terms did not easily accommodate irregular additional distributions, and because Caroline, Elizabeth, Miriam and Ruth had all concluded, independently and in succession, that departing from the specified distribution schedule was likely to produce requests for further departures, and that the schedule was the schedule for reasons that the trust's founder had intended to be structural. Percival Cartwright had received his quarterly distributions for over 20 years without complaint, before the late 1920s changed his view. What changed it was not primarily the absolute amount of the distributions, which had increased steadily as the trust's income grew. What changed it was comparison, the comparison between what the trust paid him and what he understood other investments of comparable size were generating in the boom years of the mid to late 1920s. His financial advisor in New York, a man named Harrington, who had been in the market since the early years of the decade, and who had benefited substantially from the boom's directness in rewarding confidence, had told him several times that the Trust's conservative management was costing him money. He had found this argument increasingly compelling as the 1920s progressed and the markets kept going up. What Harrington had not told Percival, or had told him in terms that Percival had not fully absorbed, was that markets that go up without interruption for extended periods are not normal markets, and that the investment strategies that maximize returns in such markets are not the strategies that survive when normal conditions return. This was not unusual advice to fail, to give, or to fail to receive. The late 1920s were a period in which the financial press and the financial advisors who fed it were largely in agreement that the new era of permanent growth had arrived, and that the old cautions were the superstitions of people who hadn't understood what was happening. Harrington was a product of this environment. He was competent within its assumptions. He was not competent beyond them. Elizabeth Cartwright Marsh had lived through the panic of 1907 as the Trust's primary trustee. She had made the decision in September of 1907 to convert the Trust's equity positions to cash and short-term government bonds, and she had made it on the basis of her reading of the financial press over the preceding 6 months, and her own analysis of the credit expansion that had been driving equity markets. The decision had been entirely her own. She'd consulted no financial advisor, because the financial advisors who were available to her in 1907 had not been recommending caution, and she'd concluded, on the evidence she was reading, that caution was appropriate. The Trust's annual report for 1907, 18 pages in Elizabeth's careful hand, described this decision and its rationale in full, the specific indicators she'd been watching, the threshold that had triggered her decision to convert, the timing of the conversion relative to the September deterioration in markets, and the results as of the year's end. Miss Fenwick read this annual report, and all the annual reports surrounding it, with the attention of someone who is constructing an argument that needs to be historically complete. She calculated the Trust's total return across each year of its existence. She compared the Trust's performance against the equity markets in each year. In the strong years, the Trust underperformed the market because it was conservatively invested. In the difficult years, 1893, 1907, and the brief recession of 1920, the Trust preserved capital while markets fell. The cumulative effect of this pattern, when she ran the numbers across 44 years, was that the Trust had outperformed a hypothetical fully equity portfolio over the full period, because the losses avoided in down years had compounded as much as the gains missed in up years. This was not a counterintuitive finding for anyone who had studied financial history at any length. It was a finding that the boom conditions of the 1920s had made temporarily counterintuitive to people who had been in the markets only during those boom conditions. The January 1929 hearing was attended by Percival and his 2 cousins, their attorney, Miriam and Ruth, Miss Fenwick, the Trust's solicitor who had succeeded Horne's firm, and the judge. It was, by the standards of family litigation, a quiet proceeding. Miss Fenwick's presentation was orderly and complete. She moved through the founding letter, the trust instrument's terms, the 3 successions of trustee, the performance analysis, the comparison with alternative strategies, and finally the current conditions in the specific markets that Percival had proposed as alternatives to the Trust's existing investments. On that last point, the specific alternatives, she was particularly careful to present only facts and not predictions. She noted the price movements in Florida real estate from 1926 onwards, the credit conditions underlying the equity market's recent performance, and the Trust's current position. She drew no conclusions about the future. The court did not require her to. By the time the judge issued his written opinion 10 days after the hearing, the first of the New Year's financial news was already suggesting that the markets Percival had favoured were more fragile than their recent performance had indicated. The judge's opinion noted the exemplary quality of the Trust's records and the demonstrated prudence of its management over 44 years, and it dismissed the petition without requiring re-argument. Miriam filed the opinion in the legal correspondence drawer of the 4th Cabinet under the year 1929, in the same location she would have filed any other court document pertaining to the Trust. The stock market's collapse in October of 1929 was the event that everyone who lived through it would describe for the rest of their lives, where they were when they heard, what they thought, how long it took to understand what was happening. Miriam was in the Pratt Street office. Ruth was in Hartford visiting her daughter. They spoke by telephone that evening. Their conversation, neither of them would later recall in detail, but Miriam would say that they had mostly been quiet on the telephone, which was a thing that happens between people who have been working together long enough that they understand each other's silences. The Trust's capital at the end of 1929 was essentially what it had been at the beginning of the year, because the Trust's holdings in the autumn of 1929 were primarily government bonds and conservative real estate, the same positions they had maintained since before the petition. The investments that Percival had proposed were largely worthless, or substantially reduced, by the spring of 1930. The Florida real estate project that Frederick had wanted the Trust to support was in receivership. The manufacturing concern had closed. Clement had lost the bulk of his personal investments. All three continued to receive their quarterly distributions from the Cartwright Trust, which continued to pay as it always had, reliably and on schedule. Ruth Marsh was the last surviving trustee and the one who distributed the Trust's principal in 1942 at the conclusion of the three-generation period. The distribution was to the charitable interests that Elias and Carolyn had identified at the Trust's founding: the college in New Haven, the hospital in Hartford, the school in the Cartwright family's town. The amounts were larger than anyone outside the Trust had expected, which was the result of 44 years of careful compounding. The accountants who handled the distributions verified each calculation twice, because the numbers were large enough that the accountants wanted to be certain, and they were. The principal was distributed in full over a period of 4 months in 1942. The filing cabinets were donated to the Connecticut Historical Society. The Pratt Street office was relinquished at the end of the same year. The south-facing windows of that office let in the winter afternoon light in December of 1942 for the last time. Ruth stood in the empty room after the cabinets had been removed, before the keys were returned to the building's owner. She was 75 years old. She had been connected to the Cartwright Trust since her birth, in the way that the children of trustees are connected to the thing their parents administer, aware of it as a presence in family life, understanding more of it as they grew, finally becoming stewards of it themselves. She had managed it, with Miriam, for 21 years. She had seen it survive 2 crises that destroyed comparable private trusts, and she had seen it produce, at its conclusion, a distribution that permanently funded 3 charitable institutions in Connecticut. She looked at the room where the cabinets had stood and thought, as she told her daughter later that evening, about Caroline beginning the accounts in 1885, in a different room in a different building, setting up the format that all 4 of them had followed for nearly 60 years. A good format, Ruth said. It held everything. The annual report that Caroline Cartwright wrote for 1893, the year of the financial panic, was 27 pages long, which was the longest report she had yet written, and which reflected the complexity of what the Trust had done that year. She described, in chronological order and with specific dates, the sequence of observations and decisions that had led her to sell the railroad bonds in June, the specific indicators she had been watching, the threshold at which she had concluded that the risk-reward balance no longer justified holding, the mechanics of the sale, and the reinvestment of the proceeds. She then described the panic itself, beginning in late summer, and the Trust's position through the autumn. She ended with the year-end figures and a brief observation that the Trust's performance in a difficult year reflected the value of conservative positioning, which she defined not as timidity, but as the maintenance of a sufficient margin between the Trust's assets and the risks that the market was currently offering. The report was written without triumph. It was written with the clarity of a record. Elizabeth had read all of Caroline's annual reports before she became trustee. She had read them as a form of professional preparation, beginning in her early 30s when she had started taking a more active interest in the Trust's management. She had annotated them in pencil, notes to herself about the reasoning, questions about specific decisions, cross-references to the market conditions she had found in the financial press. These annotations were a form of the thinking and writing that Elizabeth used throughout her professional life, the process of understanding something by writing about it, of making the implications of a fact visible by following them on paper. Caroline had approved of the annotations. She had told Elizabeth that the only way to understand a document fully was to argue with it, and that the pencil annotations were Elizabeth's side of the argument. Miriam had inherited Elizabeth's annotated copies of Caroline's reports when she became trustee. She had also read them, and had made her own annotations in a different colour of pencil, which meant that the 2 generations of commentary were legible alongside Caroline's original text. Caroline's baseline, Elizabeth's response, Miriam's response to Elizabeth's response. The reports read, in this form, as a continuous conversation across time about the same recurring questions: how to balance income generation and capital preservation, how to respond to market conditions that were ambiguous, how to explain decisions to beneficiaries who wanted to understand the rationale. Ruth had also read them, and had made a few additions in her own hand, but she'd found Elizabeth's annotations sufficient and had mostly extended them rather than adding new directions. The quarterly distribution letters that the trust sent to its beneficiaries were, by the standards of family trust correspondence, unusually full. Most family trusts communicated with their beneficiaries through brief formal notices that stated the amount and the date and nothing more. Caroline had, from the beginning of her trusteeship, included with each distribution a brief note about the trust's general condition and any significant changes in its management. These notes were not financial reports. They were human communications of the kind that maintain relationships across distance and time. They reported on the investments in general terms, on the condition of the Hertford office, on significant developments in the broader economic environment. They were, in effect, a form of transparency that most family trusts of the period did not practice, and that the beneficiaries had come to expect, even if they did not always read them with attention. The Connecticut Historical Society's archive of the Cartwright Trust records is housed in the same building as the other family trust records that the Society has accumulated over a century of accepting donations from the region's families. The Cartwright collection is one of the more complete: 44 years of annual reports, quarterly distributions, investment records, beneficiary correspondence, and legal correspondence, along with the founding documents and Elias's letter. Researchers who work with the collection tend to comment on the consistency of the methodology across 3 generations: the same account categories, the same reporting format, the same explanatory approach. One researcher, writing in the 1980s, called it an example of institutional memory maintained across biological boundaries, which was an academic way of saying that the habit had been learned and passed on, and that what had been passed on was not just a method but the understanding of why the method mattered. The lesson of the Cartwright Trust, as Miss Fenwick had presented it to the court, and as she later summarised it in a professional paper she wrote in the 1930s, was not primarily about investment strategy. It was about what she called institutional continuity across biological boundaries, the ability of an organisation or a practice to maintain its essential character as the individuals who embody it change over time. Most family trusts failed this test within 2 generations, because the habits and knowledge of the first trustee were not transmitted to the second with sufficient completeness. The Cartwright Trust had succeeded it, because Caroline had been a conscious transmitter as well as a practitioner. She had documented her methodology in the annual reports. She had included Elizabeth in every significant meeting. She had explained her reasoning in writing so that the reasoning survived her in a form that Elizabeth could absorb, use, and pass on. The Nephews had received, over the life of the trust, more in distributions than they would have received under almost any alternative management scenario, including the speculative ones they had proposed. Miss Fenwick had calculated this in her analysis for the 1929 hearing, and the calculation had stood up to scrutiny. The trust's conservative management had produced lower income in the strong years, which was what the Nephews had focused on, but had also preserved capital through the difficult years, which was what allowed the strong year income to compound. The net effect over 44 years was higher distributions than a more aggressive strategy would have produced, even before accounting for the 1929 crash, which would have catastrophically reduced capital under the speculative approach and dramatically reduced subsequent distributions. The Nephews had been seeking a larger share of a smaller pie. They had, without knowing it, been arguing against their own long-term interests. The Connecticut winter arrives in earnest by December, and the Pratt Street office in December had always been cold by late afternoon, even with the heating system running, because the building was old and the windows let in the cold in the way that old windows do. Miriam and Ruth had kept a small coal stove in the southeast corner of the office for the afternoon hours, and the warmth of it on a December afternoon, combined with the winter light coming low and horizontal through the south-facing windows, had always given the office a particular quality that both of them had associated with the trust's work. The combination of cold outside and warmth inside, of the pressing season and the contained comfort of the annual reports being written in the annual season of closing down and preparing for what the spring would bring. This was, for both of them, the natural environment of careful management, a warm room in a cold season, the records at hand, the decisions to be made with clarity and without haste. Close your eyes and let the filing cabinet stand somewhere behind you. Let the records sit in their drawers, the annual reports in their folders, the distribution ledgers in their rows, the correspondence filed by year and category. Let the accounts balance as they always have. 44 years of careful work have brought you to this moment, and this moment is enough. The trust has survived what it needed to survive. The evidence is complete. The judge has read it. The ruling is in the legal correspondence drawer filed under the year it was issued, ready for anyone who needs it. The winter light through the south windows is almost gone now. The coal stove ticks in the corner. The work of the day is finished, and the work of tomorrow will begin when it begins. For now, rest. The records are in order. Everything that needed to be written down has been written down. Sleep, the way people sleep when they know where things stand. The parlour is quieter now. The afternoon has moved into evening without announcement. It does this in November, the light thinning and then simply going, the room gathering its shadows in the corners and against the bookshelves, and under the writing desk where the lower drawer sits closed, its contents undisturbed. The coal fire has burned lower but not out. Someone has banked it for the night, the particular gesture of a person who knows a fire well enough to know how much it needs to be restrained versus how much it needs to be left, and who has made that judgment with the ease of long practice. The room holds its warmth. The curtains, fully drawn now, keep the November night at bay. On the desk, the pen is still, the ledger is closed, the correspondence is filed, each letter in its envelope in its folder, each folder in its year. The original deed is where it has always been, in the lower right drawer, with the certified copy behind it, and the attorney's covering letter behind that, and the receipt from the county recorder's office tucked into the front pocket, dated and stamped and perfectly legible. These women are sleeping now, if you will allow the image. Constance and Harriet in their quiet bedrooms above the wisteria porch. Margaret in the farmhouse where Henry had laid down the documents in order before he left. Agnes with her ledger beside her on the Cambridge desk. Eleanor with her diary volume for 1927 open to the last entry, written in the familiar hand. Miriam and Ruth with their filing cabinets locked for the night in the Pratt Street office, 5 floors above the amber-lit street. They have done their work. They have kept their records. They have waited with the particular patience of people who understand that time is on the side of the document and not on the side of the claim, and they have been right every time that the document would be enough. What they shared was not wealth, though some of them had it, not education, though they had that too in varying degrees and kinds. What they shared was the habit of mind that makes a record, the belief that what is true ought to be written down, and that what is written down can be found, and that what can be found can speak for itself in the clear cold light of a February morning in a county courthouse, where the evidence is all that matters. The lamp is burning low. There is no reason to stay awake any longer. The documents are in order. The records are complete. Outside, the November night has settled into its deep and very quiet cold. The kind of cold that asks nothing of you, except that you stay warm, that you stay still, that you let the world take care of itself for a few hours while you rest. Rest now. Everything is in order. The deed is exactly where it belongs. Thank you so much for listening. If you enjoyed this collection, please consider leaving a like and subscribing to the channel. It helps us continue making stories like these. We'll see you in the next one. Before you drift off, did any of these women remind you of someone you know, or someone in your own family's history who kept careful records, who held their ground quietly, who trusted the documents when others didn't? Leave your thoughts in the comments. We read everyone. Somewhere in a county archive in Pennsylvania there is, perhaps still, the deed book for 1872, and on a specific page in that book is the entry recorded by the county clerk on a December afternoon. A joint tenancy deed in fee simple, parties Constance and Harriet Whitfield, property described by metes and bounds, consideration stated, signature of Alderman Josiah Fisk as attorney, duly witnessed and notarized and sealed. It is in there among hundreds of other deeds from that year, in no way distinguished from them by its appearance, the same black ink on the same cream pages in the same careful clerk's hand. What distinguishes it is not visible. What distinguishes it is the care with which it was drawn, the specific choices of language that Fisk made, the addendum he added 3 pages later at Constance's request, in March of 1878, the covering letter that he sent with the certified copy and that Constance filed in the lower right drawer of the desk. The deedbook entry does not contain any of that. The deedbook entry is simply there. The mineral rights document in the Pittsburgh solicitor's file, the registered copy of Arthur Langford's will in the county probate records, the circuit court ruling declaring Eleanor Braddock's quitclaim void, the written opinion dismissing the Cartwright Trust petition, all of these documents exist in some archive somewhere, in the dry and patient manner of documents that have done their work and are now simply waiting. This is what documents do after they have served their immediate purpose. They wait. They wait in the temperature-controlled drawers of historical societies and the cardboard boxes of county clerks and the acid-free enclosures of university archives, waiting for the researcher who will come looking, or for the moment when something that seemed finished turns out to need to be revisited. The researchers who have found these documents over the years have been struck, many of them, by the quality of the records surrounding them. Not the documents themselves, the deed, the registered will, the court ruling, but the peripheral records, the household ledgers that confirm the facts on the ground, the diary entries that fix the dates, the correspondence that explain the intentions. These are the records that the women themselves kept, not the records produced by the legal system in response to what the women did. They are the primary texture of the lives, what the house cost to heat in January, what the kitchen garden yielded in August, what the doctor said on the 14th of March. Out of this texture, when the moment required it, the specific relevant facts emerged. She was in bed on that date, there were no visitors after the 7th, the documents had been in the lower drawer since 1872. The facts were never manufactured for the purpose. They were simply already there, having been recorded because recording was the habit. These women lived in a period that offered them, in general, fewer legal protections than men received, fewer professional opportunities, fewer acknowledged avenues of power. Within this context, the protection that careful record-keeping offered was specific and limited, but real. It made the truth about their property and their intentions visible in the one forum where visibility mattered, which was the legal record. It did not make their lives easier in the general sense. It made the specific moments when their rights were challenged winnable, which is a different thing. The cases we have looked at tonight are not examples of the law working well for women as a class. They are examples of specific women, with specific documents, in specific circumstances, making the law work for them because they had what the law required: evidence. Before you let sleep take you the rest of the way, think, if you will, for a moment about your own records, not the official ones, the deeds and wills and bank statements that the formal systems maintain on your behalf. The other ones, the notes you keep, the photographs you take, the messages you save, the files you label, the small acts of documentation that constitute, in aggregate, the record of a life as it was actually lived. They are not glamorous, they are not heroic. They are simply the habit of a particular kind of attention, the habit that says, this happened and it is worth writing down. What is written down can be found. What can be found can speak for itself. The house on Prospect Hill still has its south porch. The wisteria still blooms in May. The valley below is still visible on a clear day in the way that Constance watched it for a lifetime, and Harriet watched it after her, and the school children watched it from the schoolroom windows, and the principal watched it from the office where the writing desk stood with the lower right drawer now holding petty cash. The view is unchanged. The light is unchanged. The deed is in the county records, as it has always been, as clear as it was in December of 1872, as unambiguous as Alderman Fisk made it, as durable as the intention that created it. Good night. You're in good company tonight, in the company of women who kept their records, who trusted their documents, who waited with patience for the evidence to do what evidence does when it is correct and complete and properly filed. Sleep as they slept, with the accounts settled, the correspondence in order, the lower right drawer closed. Everything is where it belongs. Everything that needed to be said has been said. The rest can wait until morning, and morning will come when it comes, unhurried and inevitable in the way of things that have always come.